ready.
Okay. We are live and on the record. Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth. Draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
And good morning, everyone. Welcome to the January 6, 2022 sitting of the Massachusetts Appeals Court. I am Eric Neyman, today sitting with Justice Joseph Ditkoff and Justice Catherine Hand, and we will be your panel today. Counsel, before we begin, I'd just like to make a couple of comments. First, this case is being live streamed on our YouTube channel. And second, on occasion, you will see the judges looking down. That's not because we are not paying attention to you, but to the contrary, we have your briefs, the case law, and all of the relevant portions of the record in front of us. So we are just simply checking your representations in real time. So with that said, we'll call the first case. It is docket number 2020-P1374, Millikin versus Commonwealth. This case is partially impounded, so I would urge counsel to, or I would remind counsel actually not to reference any impounded materials. We'll hear first from counsel for the appellant, Attorney Tennant.
Thank you, Your Honor. Good morning, everybody. May it please the court, Eric Tennant on behalf of Mr. Millikin. Your Honors, in a trial about sexual dangerousness and risk to reoffend, doctors testify about static and dynamic factors. As to the static factors in this case, they all use an actuarial to place those factors into context, the static 99R. As to the dynamic or changing factors, only Dr. Johnson sought to use an actuarial to place those factors into context. That's the stable 2007, an instrument almost identical to the static 99, but it was excluded. Exclusion of an actuarial that weighs and measures empirically guided risk factors, I would submit, was an abuse of discretion, and the stable 2007 was essentially exactly the kind of actuarial instrument routinely admissible in these proceedings. So the judge's exclusion was based on two things that I'd like to focus on. One was his determination that this instrument was not reliable for these types of proceedings, and then two, a little bit based on Dr. Johnson's limited training. So the idea that this instrument wasn't reliable for these types of proceedings, I submit, was not quite the right question. And there was a lot of debate about it, but it sort of misses the point. An actuarial is not designed to be used in settings. It's just designed to be used with certain populations. Just like a DNA test, for example, is not designed to be used in a criminal trial. It's just designed to tell you something about DNA. Fingerprint evidence, drug detection, testing, they're not designed to be used in proceedings. They just are designed to do something. And if what it does is valid, then you can talk about them.
Did you say that I'm sorry to interrupt. Did you say
Sure.
that it is designed to measure certain populations?
Yes, the idea is it wasn't designed so that we can use it in a hearing. It was designed to be used on certain populations. And so that is.
That leads to my question, because didn't Judge Doolin find that part of the problem was there was no testing showing the stable 2007's reliability as applied to long-term incarcerated populations?
They spoke about that. There was testimony about that. But when you read his findings, what he takes issue with is its use in these proceedings. So when you look at the scoring manual, and Dr. Johnson talked about this, it is clearly designed to be used for persons convicted, men convicted of a prior sex offense to determine their risk to reoffense. And it is used on populations of persons in the community, but also incarcerated. There's a whole section of the scoring manual that talks about its use with long-term incarcerated individuals. It cautions you should put it into context, right? When you're scoring a sort of changing factor of someone in that setting, you might look at it differently than someone in the community, but you can use it with that population. So that's what these tests do. If you think about the static 99, same thing. It's designed to be used on a population to tell you something about the risk to reoffend. That's all the stable 2007 does, right? What can we say about these kinds of different factors, these dynamic factors on this population? And so all Dr. Johnson was doing what courts have allowed doctors to do with the static 99, for example, an instrument that itself was validated, right? There was no real question about that. There was studies submitted and no one really pushed the idea that the stable 2007 doesn't measure what it's supposed to measure. No one questioned Dr. Johnson's application of the stable 2007, right? No one said, well, you scored this one wrong, or you didn't get this item right, or anything like that. They just said, well, why should we use it here in these cases? But that, again, I submit, is not how you're supposed to think about use of these kinds of instruments, or whether these kinds of scientific instruments are admissible. Again, you wouldn't do that in any other context. So by way of another example, if you look at some of the other cases, even in the SDP context, where we talk about what kinds of things might be admissible, right? So there was a recent case, Ortiz, about the PPG, the penile plethysmograph. So in that case, the court said, look, this instrument itself is not reliable, right? We have questions about whether it can be applied, objectively, and there's no standards. And so it went through that and said, because this instrument's not reliable, we're not going to let it in. That's, you can debate whether or not it was or wasn't a reliable instrument, but that was the question the court focused on. An older case, Commonwealth v. Reddy.
In Ortiz,
Yep.
I think our court noted, and I think it was Justice Ditkoff who wrote that case, it gets back to my earlier question. It noted that when we're assessing reliability, we're not just looking at general reliability, we're looking at reliability in the context of the specific application at issue, right?
Sure, absolutely.
And again, it seems to me, I shouldn't say it seems to me, but isn't there a basis in the record to conclude that that's precisely what Justice Doolin did consider? That the stable 2007 may be reliable in certain contexts, but in this application, you didn't satisfy your burden. And I acknowledge, Attorney Ten, you were not trial counsel.
Thank you. So I guess there's two responses to that. The first is they certainly talked about that. You're right. There was a question about, are we using this on the right population? So I don't disagree with that. If you then look at Dr. Johnson's responses and what's in the record, her responses were absolutely, you can use it on this population. So if you can, for a second, take away the idea of the proceeding, right? So we're not talking about whether you use an SDP, but can you evaluate men like him, right? Her response was absolutely. In fact, she talked about the treatment center itself having used this instrument on him in their treatment. And so one of the reasons she did this was to show how it's changed over time. And then the scoring manual itself, there's a whole section that talks about its use on long-term incarcerated individuals. It anticipated to be used on them, right? The idea is you want to use it on people who are or are going to be in the community. Now, you don't want to use it on someone who's not going to be in the community for 20 years. That doesn't make sense. But someone who's soon going to be in the community, you can use it to determine their risk to reoffend. And then the second part of that.
I'm sorry to interrupt you again. It's the problem with Zoom, but did Judge Doolin credit Dr. Johnson's findings that you're pointing to?
Sure. So that was going to be the second part of the question, is when you look at what Judge Doolin said, he didn't say anything about that. And he said twice, I don't think the petitioner has demonstrated the reliability of this device for this type of proceeding. So that's what he's focusing on. And based on the research that I've seen, all the literature says the purpose of this is not for use in a proceeding such as this, an SDP proceeding. And
had you used the term application rather than proceeding, would you be making the same argument?
If you use the term application, I guess if you're using it the way I understand that word, I would be making the same argument, which is it applies to this person, right? It's intended to be used for someone who's doing a risk assessment of someone like Mr. Millikin, who may soon be in the community, right? What can we say about his risk to reoffend?
Counselor, I mean, isn't an SDP proceeding almost always going to be a proceeding where you have someone who's been incarcerated for a long time? And it doesn't always, not 100%, but 95% of the time, it's going to be someone who's been incarcerated for a long time, hasn't been out, which Dr. Hansen wanted stable 2007 to be used for, but cautioned that there was no research supporting its accuracy for that purpose.
for the purpose. So I guess I don't get the end of the question because
Research has yet to examine the extent to which Stable 2007 provides accurate assessments of criminogenic needs among offenders still in prison while serving long sentences. That's in the coding manual.
so that's upon the development of the Stable 2007. Then what happens is, and what they talked about at the hearing and some of the submissions of the research was, we've now studied this to see whether it validly can do what we want it to do, which is predict risk to reoffense for persons in the community. And the more they studied it, the more it became appropriate to use. And so now in 2000, I guess 18-ish, whenever this trial was, 11 years removed from the development of that actuarial. Now what the doctor is saying is, we've studied enough to know that it actually does have validity, and validity for assessments of this kind when I am trying to determine X person's risk to reoffend. So at the point that this was being introduced or attempted to be introduced, there was enough to say, yes, now you can do this. Again, putting aside where we're using it, whether it's a probation officer or an expert in SDP proceeding, there's enough to say, if I, a doctor, want to talk about what this long-term incarcerated person's risk to reoffend is, who may soon be in the community, this is one of the actuarials I can use.
So, Counselor, I just, maybe I don't quite understand the coding manual, because it says revised 2014. And I was just assuming that the part I was reading was revised then, but maybe I'm assuming that incorrectly.
If you're looking, are you looking at the workbook maybe? That's from 2017?
Beginning of the coding manual at 229 says revised 2014. Then I was reading from later in the coding manual at 249 in the record. So I might have been making an assumption here that's not justified.
I think, no, I think you're reading it correctly, but if the explanation is, I believe. So the coding manual is developed in 2007, right? Stable 2007. It gets revised over time, and normally the things that get revised are sometimes how to score certain items. So they do more research and say, well, actually we should score it this way or that way. And then the kind of scoring itself, right? So this number means this level means this recidivism rate. So there are revisions going on, but a lot of time the bulk of the introductions and things like that are from 2007. So not literally everything gets revised, but it's updated, right? New scores, new items, less items, new recidivism rates, less recidivism rates, etc. So I believe that's what that's referencing to. So again, in 2007, when it first comes out, this is what we're trying to do here. This is what we want to do. Research will tell us if we're right or wrong. Research comes along and says, yep, this is valid. It's doing what it's supposed to do. It's incrementally predicting recidivism, with these factors. And what I was going to say before, again, by analogy, exactly like the static 99, which is an actuarial used in these proceedings.
Kelsey, your time is running low,
Sure.
and you haven't talked about the application of it. And Dr. Johnson's basically not following the high quality recommendations of the coding manual. I think I'd like to hear about that.
So I'm not sure that there was any issue with how she scored it. I'm not sure there was any issue with her use of it. There was some question by the judge that maybe she didn't have enough training. I don't know if that's what you're referencing, Your Honor.
The coding manual has 7 recommendations for doing this in a quality way, and in Cross, the Commonwealth went through them, and she basically hadn't done any of them. No, she had done the inter-rater reliability trials, but everything else, clinical supervision, peer review, reassessment, quality control process. And she in fact said that she wasn't doing that stuff because she wasn't using it in a treatment program.
That's right. So one of the things you say is, okay, once you have a score here, then you say, what are you using it for? So are you a treatment provider using it in a treatment context? If so, then here are things you should do. Are you a probation officer, whatever it is? So not all those apply to every person who is scoring this. For her purpose, what she wanted to get out of this was, let me look at the dynamic factors we all agree we have to look at, all the doctors look at. Let me look at those factors. Let me plug that into the score, let me get a score. Once she does that, then as an expert, just like, the same way they do with the static 99, she says, okay, this is what this score tells us here. I'm not his treatment provider, so I don't need to talk about how this issue should be addressed in treatment. I'm not his supervisor. I don't need to talk about what kinds of, the conditions I should place on him. I just need to say, for purposes of what I'm using it for, this is what it tells me about his risk to reoffend. So those were not a list of everybody must always do this. That's a list of, these are things that you should think about depending on the context in which you're using this.
But why can't the judge be concerned about whether she can make reliable predictions when she isn't following the coding manual's recommendations for high quality predictions?
I suppose he could. He didn't say that. He didn't say that was a problem with it. The most he articulated was that he thought she had fairly limited training, but then again, limited training about whether this applies in this proceeding. There was no, the record doesn't show that she misscored this or that anyone questioned that she misscored it in any way. The record doesn't show that she didn't look at a factor a certain way, or that her training wasn't enough to help her to teach her how to score the instrument, how to use the instrument, right? So there was no pushback to her use of the instrument, just about whether she could say that it could be used in these proceedings and whether the instrument could be used in these proceedings. And the judge was very clear. He didn't say a lot, but what he did say was about those very specific things.
And I see your time has expired. Let me just check with the panel. Justice Ditkoff, further questions? No, Justice Hand?
No, thank you.
Thank you, Attorney Tenen. We'll now hear from counsel for the Commonwealth.
Good morning. May it please the court, Jean Holmes for the Commonwealth. The trial judge did not abuse his discretion in excluding the stable 2007, and there is no cause to disturb the jury's verdict that Mr. Millikin remains a sexually dangerous person. In this particular case, the only individual, the only expert out of 9 experts that were participating in this, the only one who used the stable 2007 was Dr. Johnson. Mr. Millikin proposed to use the stable 2007, even though it has never been admitted or used.
Counsel, do we know that no one used it, or just no one included it as a basis for their opinion?
There was no indication that any of the experts used it, Your Honor. The witnesses, the 2 qualified examiners testified they used the static 99R, and that was in their reports. The Community Access Board, their report does not reflect the use of a stable 2007 when they were doing their review. In fact, the testimony is that the Community Access Board doesn't use even the static 99R because it's not intended for to be used in a group evaluation, which the CAB is involved in. And Dr. Pla did not indicate that he used the stable 2007 either. In fact, the stable 2007 has been used in treatment for treatment. And in fact, that is appropriate. The Commonwealth's position is because Dr. Hansen, who created the stable 2007, says that is the value of the 2007 is to identify the dynamic risk factors that the treatment providers can then target for purposes of addressing treatment that is most needed for that particular individual, and then change as it goes on. So that is the idea behind it, and that was what the Commonwealth focused in on and the judge focused in on, which is that the stable 2007 may well be a tool that could be used for treatment and treatment recommendations and supervision, but it is not a tool to be used for purposes of sexually dangerous persons.
Counselor, sorry.
No, go ahead, Justice Ditkoff.
Counselor, if the science is that this is a useful thing to use in treatment, because if you can address certain things that stable 2007 tells you, then you reduce the chance of recidivism. If that's the proper use of it, then why isn't it proper to say, hey, this defendant has accomplished the treatment goals that stable 2007 says you do, which means that his chance of recidivism is less?
Well, for a couple of reasons. And one is that just because a tool is used for treatment purposes doesn't mean that it would be of value for purposes of determining whether someone remains sexually dangerous. In addition, Dr. Hansen himself has stated that the Stable 2007 does not provide any greater predictive reliability as it relates to sexual recidivism or prediction of sexual recidivism, which is what is happening in terms of a sexually dangerous person case. In terms of a treatment proceeding, they're not using the tools to determine whether or not someone is likely to reoffend. They're determining this person has been, in this case, committed to the treatment center, and we need to determine what are the first things that he needs to address and what are the next things. And so it's a treatment process, but it's not for the prediction of sexual recidivism, which makes it quite different than the static 99R, contrary to my brother's position, because the static 99R is a tool that is designed for purposes of prediction of sexual recidivism. Dr. Hansen has made it very clear that the Stable 2007 is not. Also, I would point out in this particular case, it's interesting because the court was aware, the trial judge was aware that although Dr. Johnson felt and Mr. Milliken was proposing that the Stable 2007 that Dr. Johnson did should be admitted because it's reliable, he also, Mr. Milliken, was moving to exclude the Stable 2007 that had been done by the treatment providers in his treatment records. So that in and of itself really is stunning, the fact that he's putting forth that this tool is a reliable tool, and yet he wants to exclude the Stable 2007 scoring that was done by the treatment providers, which actually would have been somewhat consistent with Dr. Hansen's position, which is you do the Stable 2007, then you do it again, and you do it again, and you're looking for change. Dr. Johnson wanted to just extrapolate out that she was going to do a test and then put it forth. Another problem with the validity and reliability is that what Dr. Johnson was putting forth was not, in fact, reliable and valid based upon the proponent of this tool. Dr. Hansen requires that the PPG be used. We know that the PPG is inadmissible and has been ruled inadmissible in this court. In addition to that, Dr. Hansen also requires that the risk labels that are used in the static 99R are to be used when using the Stable 2007. In this particular case, again, Milliken's counsel had moved to exclude the risk labels for the static 99R, and therefore was also moving to exclude the risk labels that Dr. Hansen says should be used with the Stable 2007.
This is the second time in 5 minutes you've taken the position that the defendant's litigating position is a relevant consideration in a Daubert decision. Is there any precedent to support that?
Well, it's his burden to show that this is valid. My position is that the position that he took in and of itself puts into question the validity, and it certainly hampered him from meeting his burden to prove that, in fact, this tool was generally accepted in the scientific community and also reliable. In fact, the judge had evidence rather in the articles that a survey was done of individuals doing treatment for sexual offenders as well as for sexually dangerous person evaluators. Out of the 59 sexually dangerous person evaluators, most of them used the static 99R. 33% had used the Stable 2007. Some were using none, and actually there was a decline.
Well, that actually begs.
Sorry.
That begs a question I have, which is the number was 33.9% said they used the Stable 2007. So let's call it 34%.
Mm-hmm.
Let's draw that back to a more fundamental question. When we are evaluating whether or not a scientific theory or process is generally accepted in the scientific community, what do we look to? What does the case law instruct us?
Well, it would look to the community that is involved in the theory that is being put forth, or the tool that is being used. In this particular case, so we're looking at the individuals who were doing sexually dangerous person evaluations. Only 34% of them had used those, and that was initially, but the amount.
I don't know why you say only 34%.
Exactly.
A third of doctors are using a tool. I would think it's pretty generally accepted. I mean, if I go into a doctor and he says, oh, a third of doctors like to use this test to detect whatever they're trying to detect, I wouldn't say, oh, that can't be a good test. That seems like that's the kind of thing that should be in.
The survey article also indicated that that was declining, however, too. So again, you would think if it was generally accepted that it would continue to rise in acceptance, and that was not the case based upon the survey that was done in the Kelly article that was before the court. In addition, you have, in this very case, we had 2 qualified examiners, neither of whom used the stable 2007. Mr. Millikin had another retained expert who didn't use it. So the only expert in this case who was using it, in this case, was Dr. Johnson.
Do we know that none of them used it, or just none of them mentioned? Did any of them testify they didn't use it, or they didn't put it in the report as a basis for their opinion?
There was no evidence that they used it, Your Honor. So
There's no evidence they didn't use it, right?
there's no evidence that they used it or didn't use it.
So
Right.
let's go back to that 33.9% number. What constitutes generally accepted in the scientific community? I know there's no specific number, but does it have to be greater than 50%? I mean, what percentage would be enough?
Well, I certainly would think that 50% would be a point where we would say, well, that's getting there. I mean, generally, general acceptance I would suggest to the court is certainly more than 50% of individuals find that this is something that we're going to use. And like I said, and they are using it presumably in the way in which Dr. Hansen, the creator of the tool, is putting it forth, which is relying upon the PPG and introducing that as part of the stable 2007 scoring, as well as relying upon the risk labels that council was moved to and successfully moved to exclude. So again, there's the general acceptance. I think it would suggest that it would be more than 50% would be using it for general acceptance. But in any event, we still have the fact that the tool has not been shown to be reliable for the purpose of this trial, which is whether or not Mr. Millikin remained a sexually dangerous person. And Dr. Johnson was very clear that she had not done any of the repetitive tests. The trial judge, in fact, found her testimony, in fact, concerning, because when pressed on cross-examination, she eventually said, well, something's better than nothing. And that simply, is really not the test for general acceptance or reliability for a tool.
Am I correct that the Commonwealth, and I don't think it was you in this case, but that 3 months prior to this trial, the Commonwealth made the opposite argument? That is that the Commonwealth attempted to introduce the stable 2007 in an SDP trial, and the petitioner in that case made the opposite argument, that it wasn't reliable under Daubert and Lanigan?
I don't recall.
I think it's in the record appendix at pages 517 and 521. If I'm not mistaken.
So, and again, obviously that argument was not persuasive with the court at the time. I don't believe that there was a Daubert-Lanigan hearing. I note that there is one decision here published in Massachusetts, not unpublished in Massachusetts, that does address the stable 2007, the Rodriguez case, which excluded it. So the court did ask both counsel at the hearing, which I was trial counsel, but asked both counsel for any cases here in Massachusetts where this particular tool had been used. And neither myself or trial counsel for Mr. Millikin had any cases on point. I think the Rodriguez case may have been decided after the trial, but that is the one case here in Massachusetts that would support the fact that the trial judge did not abuse his discretion in excluding the stable 2007 for purposes of a sexually dangerous person proceeding. And this particular tool really would not have addressed the fact that the Commonwealth's position is that the evidence was overwhelming, contrary to what counsel said in his brief, that Mr. Millikin still continued to have statutorily and personality defined personality disorders. Even Dr. Johnson agreed that he met both statutory and personality disorder statutorily. Also agreed clinically that he was a pedophile or had pedophilic disorder and had antisocial personality disorder. His antisocial personality disorder had continued almost right up to the eve of trial, including an incident where he was involved in a horseplay incident that the jury saw the video of Mr. Millikin and another resident engaging in slapping faces repeatedly in the course of this visit to the library. So the evidence was overwhelming, and respectfully, this particular tool, even if it had been admitted, would not have been something that would have been helpful for the jury, especially given that it was not being presented in a fashion that was proper under the creator of the tool, by way of excluding the PPG, which is inadmissible and therefore properly excluded, and as well as the labels. And if there's no further questions, I'll rest on my brief.
Seeing none, the case is submitted. You are going to be videoed, so you will be on our YouTube channel. And please keep in mind, both when you are arguing and when you are not arguing, that not only is this being live streamed, but that the live stream is preserved for future viewers. Unless there are any questions, the court clerk will tell us when we are live and I will call the case. Any questions?
No, Your Honor.
Excellent. Okay, Ali, we're ready when you are.
Okay, we are live and on the record.
Calling our next case, docket 2020 P129, Commonwealth versus Vasquez. This case is partially impounded, so I would ask counsel to please refrain from referencing any impounded materials during argument. We will hear first from counsel for the appellant, will be Attorney Burdett.
Good morning, Eric Burdett for Pedro Vasquez. The issue before Your Honors today is a narrow one, whether or not the motion judge erred in applying the balancing test outlined in the Bonnet case and originating in Rivario, United States versus Rivario. The motion judge erred in three ways. First of all, the motion judge overvalued the factor of the informant's safety in determining whether or not to disclose the privileged information of the informant's identity, and undervalued the defendant's right to a fair trial as constitutional rights. Second of all, the motion judge made erroneous credibility determinations, effectively taking the incorrect role in the hearing when it wasn't a question of credibility, but materiality of the privileged information.
Could I ask you a quick question on that, Attorney Burdett? Is it your client's position that the judge erred in making credibility assessments?
Yes, Your Honor. The role of the hearing was to determine whether or not the privileged information was material to the defendant's claim, to his arguments at trial. And
could I just ask one other thing before you go too far down that road, and ask,
sure.
Didn't trial counsel suggest as one of the reasons for having the hearing initially that it be to allow the judge to make credibility determinations, to your point?
I think the credibility at issue was the informant, and whether or not the informant would be relevant to the trial defense, whether or not that witness needed to be called at trial. And the informant there was a question of the informant's credibility there. But
well, let me follow up on that, Attorney Burdett. First of all, let me follow up with a acknowledgement, and that is that you should both know that the panel has reviewed the impounded materials in camera. And secondly, following up on Justice Hand's question, doesn't the judge in this context have a gatekeeper role?
Yes, Judge, but the when the case was remanded for hearing, it was explicitly stated in the Court of Appeals order that the affidavit by the defendant was enough to warrant the secondary part of bonnet framework to kick in, whether or not the defendant was entitled to the balancing test. That balancing test, the role of the court in that balancing test is not to decide whether or not what the police officer is saying is true and what the defendant is saying is not true, but to determine whether or not that privileged information is material, meaning that the judge needs to determine whether or not the privileged information either makes the police officer's version of events more likely or more credible or supports the defendant's position.
But doesn't that inherently involve some credibility determination? I note that in that Rule 23, our court said, quote, "The assertions of the defendant's affidavit, if credited, adequately raised a potential defense that the drugs were planted because he had refused to become a police informant," end quote. We use the term "if credited." So isn't that a signal to the judge that credibility determinations must be made in the first instance?
I think there's certainly some credibility determinations, plausibility, whether or not what the defendant is saying could even be in the realm of possibility is certainly something the judge needs to determine, because that is essential to materiality. But the role of the judge isn't to take the place of the jury here and to decide outright whether or not the defendant's claims here are just beyond belief. But rather,
let me ask you this. How does having the informant's identity help the defense?
sure. So I think there's a number of questions that would have been relevant to the defendant's version of events. So I don't want to go into all the details of the defendant's allegations about what happened in this case, Mr. Vasquez's claims, but effectively what he was saying is that he had no knowledge of the narcotics that were discovered in the vehicle he was driving, and that therefore it must have been placed by either the informant or by law enforcement as a way to coerce him into becoming a cooperating witness. Therefore, the basis of knowledge for the informant's knowledge about the defendant and potentially any drug enterprise that existed, how the informant knew that those narcotics were in the car or was familiar with the vehicle, all this could have been investigated had the informant been revealed and been subjected to cross-examination. Or
are you suggesting that with the informant's identity you could have won the motion to suppress? Is that the theory here?
Or at trial, Judge.
Well, walk me through trial. How does having the informant testify help you at trial? Another witness saying that they saw him with drugs.
It would have enabled the informant, and the defendant in this case, Mr. Vasquez, to put on the trial defense that supported his version of events. And what happened instead, because the informant,
he could have put that on. He could have testified that he never saw those drugs. Having another witness say that that's not true isn't very helpful to that defense.
Sure. I mean, well, practically speaking, we don't know what the informant would have testified to, whether or not he said that was not true. But also, it would have forced the defendant to simply present that version of his facts without having access to a third-party witness. And the court has ruled in the past, and we said it to some opinions in our brief, that where the only non-government witness is a confidential source, that source provides is essential to the jury making credibility determinations about whether or not to believe the police.
You seem to be suggesting that anytime a defendant denies that he knew about drugs, that he's entitled to the identity of the confidential informant just on the speculation that the confidential informant might say he planted the drugs.
I think if the defendant's claims were merely conclusory, so the defendant writes an affidavit and says, Judge, I had no idea those drugs were there, and therefore they must have set me up. Those sorts of claims are certainly less credible.
But why is that more credible than an affidavit claim that the judge found contradicts the evidence? Even his claim about the accent contradicts the judge's own observations and the testimony at the hearing. I mean, isn't that less credible than just a conclusory, well, it must have been planted? We have this whole story that we know is not true.
Well, I'd say here, there isn't merely a conclusory statement by the defendant. He goes into great detail about the circumstances leading up to his arrest. And on the point about the accent, which we cover in the brief, The issue there is that we don't know how that determination was made, because the conversations between the alleged conversations between Mr. Barrios, the trooper Barrios, and Mr. Vasquez in this case were conducted in Spanish, whereas at no point, at least in the presence of defense counsel, did the motion judge have any discourse with the witness in Spanish. And it's unclear whether or not the judge was in a position to be familiar with certain Spanish dialects, such as one you might hear in Puerto Rico or the Dominican Republic. So what I want to talk about is kind of the function of what should have happened at that hearing, and what actually did happen. The balancing test outlined in Bonnet is separated into two parts. The first part is to determine whether or not the privilege applies and whether or not there's a colorable reason the defendant would have access to the privileged information. So that's the first part. And then the second part is you move on to the balancing test that's meant to determine the materiality of the privileged information to the defendants.
Attorney Burdett, before you get into that, could I just ask this? Would you agree that the way that the first appellate decision in this case came out, that essentially the question of whether both sides had met their burden at the first stage was established, that the matter was remanded for only at second stage consideration as the judge treated it here? Would you agree with that?
The way I read and draw, like looking at the last paragraph of the first appellate court decision, it looks like the determination is made that the defendant's affidavit establishes that he has a colorable claim to the privileged information, but there isn't yet a determination that there is a valid safety concern. And looking at the first line of that paragraph. So it seems the second hearing, what should have occurred is there's a question of whether or not there is a valid safety concern. If then there was, then the court should have moved on to the balancing test in Roviaro.
What would be the point of sending the case on for a balancing test if I'm understanding you correctly and you're saying that the first decision didn't assume or didn't conclude that the Commonwealth had met its initial showing in stage one? Maybe I'm misunderstanding your argument.
I'm saying that the decision says there was, as noted, no such balancing occurred here. Quote, there was no attempt by the judge at an orderly appraisal of the actuality of any threat, and so on. And that's quoting Commonwealth versus Johnson, looking at the opinion. So it seems that first there needed to be the determination of the safety concern, and then the balancing test should have taken place. So, which is all kind of part of one framework to start from the beginning of it. And there were questions about that at the hearing, but I would point out that the court's ultimately finding that a safety concern existed. The questioning it in presence of defense counsel didn't reveal any particularity to the safety concerns in this case. And the judge's ultimate
that say that that's required. Does Massachusetts require that there be particularity of the type that you're looking for here?
Well, the general concern of an informant's safety certainly shouldn't have weighted as heavily in the motion judge's ruling.
But
If there were
weighed more heavily if the judge didn't credit the defendant's case.
I missed the first part of that question. Just say should have.
Wouldn't the balancing that you're talking about depend upon how the judge credited assuming that he was permitted to make the credibility determinations, how he credited the defendant's affidavit?
I think more relevant to the safety concerns was the testimony of the officer and whether or not the judge credited that the safety concerns described by the officer were valid and real. And the issue.
Why do there have to be safety concerns at all? Bonnet says would endanger the informant or otherwise impede law enforcement efforts, and then asks you to balance the interest in protecting the flow of information. Isn't it enough that people wouldn't provide information if their identities would be revealed to the defendants they finger?
So that would fall into the second portion. So first we have to analyze whether or not there is the valid safety concern. If there is.
Bonnet says, doesn't say just endanger the informant, it says endanger the informant or otherwise impede law enforcement efforts. Why isn't impeding law enforcement efforts enough under Bonnet?
Well, first of all, there wasn't any testimony that there was an ongoing investigation, at least not in the presence of defense counsel, using this informant. to impede law enforcement investigation, there would need to be some reason that revealing the identity of the informant would stop them from using that informant in the future or having.
That informant, why not other informants?
Can you specify more of the question? Is the question whether or not?
Yeah, if there's a reputation that that this unit will reveal its informants, they're not going to be able to get informants in the future, isn't that right?
Well, I think on this record that would be a speculative finding, because the officer did not discuss that if this became a practice, they wouldn't reveal it. And I would just say, as I'm running out of time, that there was a middle ground here between full disclosure of the informant's identity. The informant could have been, as defense counsel suggested, called in to testify without their name being revealed outside the presence of the defendant, with no personal identifying information revealed to defense counsel, and subjected to the cross-examination that would have aided the court determine whether or not that information was material to the defense, and determine whether or not there was a violation of the defendant's constitutional rights by keeping that conversation under, or that information under wraps. And that's also problematic with the ruling here, because much of the questioning, and part of the questioning that was essential to the judge's finding, was conducted outside the presence of defense counsel and the government, and therefore no cross-examination was enabled on those points. And in the footnote on the decision itself, it says that that the safety determination itself was founded upon testimony that was in camera.
Could the defendant have testified at that hearing?
He wasn't present.
He could. Well, could he have been brought into court through a motion, and could he have testified?
I think defense counsel could have, but the decision in the appeals court had already credited his affidavit sufficiently to trigger the second part of the balancing test. So his testimony couldn't have added to that determination. The question was whether or not
the defendant's affidavit, if credited, adequately raised a potential defense. That's what we said. So
sure.
I'm not sure I read that the same way that you do. You can answer, and your time's expired. You can address that issue.
Yes, Judge. I would just say that the purpose of that hearing wasn't for cross-examination of the defendant, but to determine materiality of the privileged information.
Understood. I think my point is that you're saying that part of the hearing was conducted outside the presence of counsel, so there's no cross-examination. I think your greater point is there's no way to contradict or to test what the witness said. One possibility would be that the defendant testifies and presents facts.
Yes, Judge, that is one part, but the right of cross-examination is the defendant's right to witnesses, and he himself is not required to be subject to cross-examination.
Understood. Very good. Thank you, Attorney Burdett. We'll now hear from counsel for the Commonwealth.
Good morning, Your Honors. May it please the court, Nathaniel Bowden for the Commonwealth. I would first say that the motion judge properly conducted the hearing, and he properly denied the defendant's motion. In his order, he stated explicitly that he did not credit the assertions in the defendant's affidavit. That means he didn't credit the alleged, coercive statements that the trooper made, the phone calls to the defendant, his wife, his father, the threats that he and his children would be deported. And the judge explicitly stated that he did not find that disclosure of the informant's identity would be material to the defendant's case. And I don't believe any further testimony was necessary, either from the CI or from anyone else, because not only did he discredit the defendant's affidavit, but he specifically stated he credited the trooper's assertions that none of those things happened. The phone calls, the threats that were discussed in the defendant's affidavit. And in the court's first decision in this case, the court explicitly stated the way this hearing was going to be conducted would be within the judge's discretion. It would be whether it was going to be in camera, whether a defense counsel was going to be present. And I think when you read the judge's statements, at least in the transcript that we have access to, this judge had a very open mind about how the hearing was going to be conducted. He stated that he very well might call the CI to testify. And he also said, he also provided a lot of leeway in terms of the questioning from defense counsel to the trooper. There was also some discussion that of course, the judge in that first hearing said he wanted the entire CI file from the state police on this informant. I believe he and the prosecutor agreed that had not really been done before, at least in their experience, in their legal experience as a judge and as an attorney. So I think the judge here had a very full picture of what was going on in terms of this particular CI and his history. And based on that, the judge heard everything that he needed to hear from the trooper and in that CI file in order to determine that this information, the identity of the informant, would not be material to the defendant's case. I would also remind Your Honor.
Attorney Bowden, can you go to, somewhat related to Attorney Burdett's last point? What's the defendant to do in a situation like this? So assume for the sake of argument that we have a situation where the defendant, just assume the defendant not only says that he wasn't a party to the drug transaction or didn't possess the drugs, assume they were planted. How is the defendant supposed to address that when, number one, he can't cross-examine the CI, and number two, the critical portion of the trooper's testimony is handled in camera, so there's no cross-examination of the trooper either?
Well, I believe it was Justice Ditkoff had earlier presented the point that the defendant could in fact present that information at trial, that, you know, these drugs were planted, I have nothing to do with this. So in a way, that defense could still be presented without the CI, without the identity of the CI being disclosed.
I'm not sure how far what a jury could perceive as self-serving testimony.
I'm not saying it would be the strongest case that a defendant could make, but it still could be before the jury. And based on the defendant's testimony, his demeanor, and all the other things that juries consider, it still would be before the jury and before them to consider. What I was also going to say is that in this case, and especially when the defendant compares it with some of the entrapment cases, in the original motion, the defendant was looking for the informant's name, his date of birth, his location of birth, his telephone number, his parents' names. This was a very broad request for information regarding the informant. And in terms of some of the cases that were cited too in terms of entrapment, and one of those cases, I believe it was the Elias case, the Commonwealth was essentially presented with the question, is John Smith CI number 5? And all they were required to respond was yes or no. And if the answer was no, the Commonwealth was not obligated to provide anything further. So just in terms of the entrapment, trying to make that comparison, I don't believe
this isn't municipal arbitration. It isn't the case the defendant either gets everything he asked for or nothing. If he's asking for too much, the judge can give him just what he's entitled to. I don't understand why it matters the defendant was asking for more than he's entitled to for our purposes.
My point, Your Honor, was just to point out that this was a very broad request for information about the informant, not just his name. They wanted a lot of information about this informant.
Can I ask you a tricky question that I actually meant to ask your brother, which is, when we look at the balancing test, are we supposed to say, how does it balance here in 2022? Do we say, how does it balance back in 2019 when the motion judge heard it? Or are we supposed to try to figure out what the balance was in 2015? I mean, take for example, well, what if the CI died in 2020? does that mean he gets released now, or if he had great reasons to protect his identity in 2015? Which of those things are we trying to figure out?
I believe, Your Honor, would be at the time of trial, which was 2015, because the defendant is saying he was deprived of his right to present a proper defense, which would have been at his trial, which would have been in 2015. And in terms of the issue about the material out, I can't say that word, about whether this was substantive information for the defendant, I believe a lot of that information was in the impounded version, the impounded hearing, so we don't have access to that. But again, based on the fact that this judge did not credit any of the assertions or the story presented by the defendant, I think that in and of itself, the information that that my brother and I are privy to, that information alone is sufficient to conclude that the judge did conduct a proper balancing test, and he properly found that this information would not be helpful to the defendant's case.
I asked a minor question on a slightly different topic, Attorney Bowden. I was a little bit surprised to see that in your brief, the Commonwealth appears to still be relying, at least to some degree, on the tipster argument, that the CI was simply a tipster and wasn't a witness to any part of the crime. Can you elaborate on that a little bit for me?
Sure, Your Honor. I mean, that was something I wanted to be before the court. I don't think it's the Commonwealth's main argument, but it's something for the court to consider, that this was not that in this type of circumstance, maybe if you didn't have this alleged elaborate story provided by the defendant, in normal circumstances, when a CI simply provides a tip, it's customary that the Commonwealth is not obligated to provide that information. So I think the Commonwealth, I think the Commonwealth has stronger arguments than that, but I didn't want that to be something that the court considered. And Your Honor, I believe I tried to make the Commonwealth's main points. If there are no further questions, the Commonwealth can rest on it.
Being none, the case is submitted. I'd like to thank counsel for both parties for excellent arguments. Thank you both.
Okay, we are live and on the record.
And now continuing the January 6, 2022 sitting of the Massachusetts Appeals Court. Call our next case, docket number 2020 P1343, Commonwealth v. Foreman. We will hear first from counsel for the appellant, Attorney Campbell.
Good morning. May it please the court. My name is Alan Campbell, and I represent Wayne Foreman in this appeal. We've raised 5 issues in our brief. I know there's no way we'll be able to cover all of them this morning. I do hope to touch on 3 of them, 2 of which are actually rather closely related. The first issue I'd like to address is that the judge abused her discretion in denying Foreman's motion for relief from prejudicial joinder. And that is, Mr. Foreman did not want the allegations from his daughter to be tried at the same time as a single isolated incident against his niece. And the court abused its discretion because it didn't properly consider what should be the primary concern in this situation is under the best interest of justice, whether the defendant can have a fair trial if both sets of allegations are tried at the same time. The judge's reasoning, it spends about 3 pages. It's cited in my brief, and the Commonwealth actually, I believe, quotes it in its brief. The judge goes through that they're related in time, that the conduct is connected in some respects, and then that the evidence at each trial, if they were tried separately, the evidence of each would be admissible at the trial of the other. The judge then says, so I'm denying it for those reasons. And then, and also the defendant wouldn't be unfairly prejudiced. But there is no discussion in the judge's decision of how it's possible. Take LF, for instance, the isolated incident. The judge has no discussion of how a trial for a single incident of indecent assault and battery for touching somebody's upper breast area while applying lotion in a parenting role, how they would not be prejudiced by hearing that the individual raped his daughter over a period of 11 years, perhaps 500 to 1,000 times. There is no, in reality, there's no way that the jury can hear that and think anything other than, oh, he did that too, he must have done this.
I gather you think it wouldn't have been admissible in a standalone trial on the niece's allegations.
Correct. And it's because it's only, the only possible thing the jury could take from that is that it's propensity, that the foreman is a bad guy who's done these things over and over again. I mean, there is the allegation that, or the argument regarding time, yes, there is some overlap of time, but that's because the allegations basically span 11 years. That doesn't mean anything that happens during those 11 years could be brought in. There actually is no, in a sense, there's no similarity in that despite 11 years of with happening once or twice a week, so 500 to 1,000 incidents of rape or abuse of one child, there isn't a single mention of a breast being touched. And that's the allegation from LF, is that the breast is touched. It was one incident, and the defense for it at trial actually wasn't even that it didn't happen. The defense was it wasn't a crime, that he was applying lotion and maybe he went slightly lower than he should have. To hear, again, testimony that he raped his daughter, and I hate to keep using this number, but that he raped his daughter 500 to 1,000 times. I don't see how it's possible for a jury to put that aside and not have improper spillover from that testimony to the evidence against LF. And conversely, the jury hears of the testimony of LF, and then they hear, oh, and he did this to another person as well. Again, the only conclusion that the jurors can draw from this is he's a bad guy, that it would be used for propensity purposes. And the case is actually, I don't want to say completely because that overstates it, but the case is really quite distinguishable from Gagnon, which was relied on by the judge in making her decision. And that involved the rape of two sisters. The sisters were being raped at about the same time. And in one instance, the defendant in that case attempted to get sexual favors from one child, and when was rebuffed, immediately went to the other child. There's some connection there. This is happening at the same time. They're related. There's nothing like that in this case whatsoever.
I don't know if I followed that. I mean, they were essentially in sister relationships since they were both living the house under the father's care, so to speak. And it wasn't the case only after the daughter finally put an end to this that the defendant started going after the niece?
No, that's not the case at all. The abuse from the niece stopped. The dates are quite confusing, and they span quite a bit of time. But to say he started going after the niece, and that's exactly the reason why it's prejudicial. He didn't start going after the niece. He at one occasion touched the upper portion of her breast while applying lotion. There's no allegation that he did anything other than that with the niece. And it wasn't that once he did it with this and it stopped happening here and then he went to the niece. That's not the case at all. At some point during this 11-year reign of terror he allegedly committed against his daughter, there was the incident with the niece. One occasion, no improper touching before, no improper touching after. An isolated incident, and just based on your Honor's question, there's spillover even to judges who know how to separate things. A jury hearing this, just simply, they couldn't think anything other than he's a bad guy. Even though there's instructions on propensity evidence and don't consider it, you can't unring a bell. And I cite a long string of cases in my brief that say the jurors actually, they're human and they can't actually do that because nobody can go through a mental exercise of separating out these things and considering them separately.
I was just going to ask you, what is your strongest case for the proposition that this error constitutes reversible error here in this case?
I would perhaps On the specifics, I'll perhaps say Ellis, and that was at a trial for rape of a child. Evidence that the defendant had fondled an older sister could only show him to be a lewd man. I think that's the strongest case. And I do have a lot of ground to cover, so unless there are other questions on this issue, I'll turn to the other. And the two issues that are closely related are that the judge erred when refusing to instruct with some form of the language from Commonwealth versus Dorval to assist the jurors in considering what to do with the mountain of other act evidence that was presented. And what the judge didn't seem to understand, and what I think the Commonwealth doesn't seem to understand, is they both responded the same way. He wasn't charged with physical abuse of the child, so it's not, the instruction isn't relevant. And while it's true that he wasn't charged with physical abuse in terms of just a straight out assault and battery for, say, hitting with a belt or something along those lines, the Commonwealth put in a mountain of evidence, of other act evidence, to show that SF couldn't say no, and that, on the constructive force argument. The defendant argued this was merely reasonable parental discipline, and it doesn't show him to be a monster. However, the Commonwealth, and the reason this is a problem is that the Commonwealth benefited from instructions from the judge telling the jurors, you can consider the other act evidence when you're considering whether or not, the relationship between the complainants and Mr. Foreman, and whether or not there was constructive force, at least as to SF. What the defendant didn't get was support for his argument from the court saying, yes, it's possible that this was just reasonable parental abuse.
Now,
Reasonable parental discipline.
does Dorval really say, is really the SJC's statement that this kind of corporal punishment is okay? Or is it just saying this kind of corporal punishment isn't a crime? Because I'm not reading this instruction as saying that it's okay to spank your children, just saying it's not illegal to spank your children.
Well, that's enough. The highest court in the state has said that you can reasonably discipline your children as long as it's reasonable, it's for the purpose of safeguarding them, and there's no substantial or lasting harm.
It says that it's not a crime to do that.
It does say that it's not a crime to do it. And if the state thinks that something is not okay, typically there are consequences from the state. And this state is essentially saying there are no consequences from this, again, as long as it's those three criteria.
So your argument is based on the idea that anything that's not a crime is okay.
I wouldn't stretch it to quite that far, but it is along those lines, yes. That it is the state allows parents to do this. The Commonwealth could have argued it's still bad, but it would have given some force to his argument, which was, as he said at trial, we're putting forth an alternative theory of how the jury should look at this. The Commonwealth gets an instruction supporting them. His argument is perfectly legitimate, but he has no instruction that supports him. So when the jury goes back and thinks through it, and they're deciding which argument to agree with, well, the court told us that the Commonwealth's argument, in a sense, is a valid argument. And the defendant didn't get the same, stamp of approval from the court. And it's not a crazy argument. It's not a far-flung argument. It's a perfectly reasonable argument, which should have had the support of an instruction, which would have been, he wasn't asking for an instruction that's not legal. It was, legal language he was looking for, or accurate language he was looking for, and he was entitled to that. And then the related issue is that Foreman was prejudiced by the sheer volume of other act evidence that was presented in this case. And to anticipate perhaps a question from you, the strongest case on this would be McMullen, the unpublished decision which I cited and appended to my brief. If you look at this case, we have 17 indictments went to the jury, spanning 11 years. For 16 of those, the primary complainant, 16 indictments, there are 36 pages of trial transcript from an 8-day trial. That's the Commonwealth's case on these allegations, is essentially 36 pages. 23 pages from that witness on the discipline in the house and the chore sheet and things like that. Every witness called by the Commonwealth testified to the discipline in the house and the strictness. In fact, one witness, Winston Foreman, the gentleman with 63 children, I believe the only reason he testified was to testify to the conditions of the house and how he thought the children were being raised. Faced with these allegations, obviously, Mr. Foreman has to present a defense. And lo and behold, every other member of the household testifies on his behalf that this didn't happen. Every one of those witnesses, I mean, obviously, they've testified that it didn't happen, so the Commonwealth's going to cross-examine them. But every witness is cross-examined on the discipline. And I didn't count through all of the pages from the 8-day trial, but there was far more evidence in this case relating to the discipline and of course, the infamous issue of the missing bar of soap. Every witness that was called by the defendant was cross-examined on the missing bar of soap. How does that help the jury decide whether or not he raped his daughter? It doesn't. It just simply, and in the Commonwealth's closing argument, I believe it's, and I wrote the note someplace, but I can't find it. I believe it spans 18 pages of the transcript. Every one, regardless of how many pages it was, every page but one relates to the discipline in the house.
So your predecessor in argument said the Commonwealth's case doesn't really live unless they can establish one thing. What was going on at 450 Boston Post Road in Marlborough was a horror like none could ever wish to experience. I assume you disagree with that?
Could you repeat the quote again? I missed the very beginning of it.
Defense counsel said that the Commonwealth's case doesn't really live unless you can establish that the household was a horror. I mean, he said that you without unless you establish.
He said that. I don't know that legally it's not accurate. It's the defense that he chose to argue because you could believe that there was a lot of discipline in the house. If you were actually a non-human thinker, a computer could look at this evidence and say it didn't happen, even though there's all this discipline that happened. I don't know that an actual person could. And then hopefully, if I could just make one more point about the acquittals and how they don't show that he's prejudiced.
Keep it to 30 seconds or less.
There was no evidence. Even if you take everything that LF said at face value, there was no evidence as to the touching of the buttocks. She said he liked his butt, and then she gave some vague answer about how it's a cultural norm. Your grandma can do it, or your dad could do it. Maybe your brother shouldn't. So there was no evidence. Even if they believed everything she said, there was no evidence to support those two offenses. And otherwise, my time has expired, and I will rest on my brief.
Thank you, Attorney Campbell. We will now hear from the Commonwealth.
Thank you, Your Honor. Good morning, members of the panel. May it please the court. My name is Konstantin Tretyakov. I'm Assistant District Attorney from the Middlesex County District Attorney's Office, representing the Commonwealth. In this case, the trial judge correctly exercised her broad discretion when she allowed the Commonwealth to introduce the evidence of the disciplinary practices that the defendant administered in his household, when she refused to instruct the jury on the parental privilege in relation to those disciplinary practices, and when she precluded defense counsel from arguing a specific biblical verse in his closing argument in relation to those disciplinary practices. So starting with the disciplinary practices themselves and their admissibility, the judge correctly determined that they were relevant to the issues that were tried and were highly contested at trial. They were relevant to the relationship between the defendant and both victims. They were relevant to the issue of constructive force, upon which the Commonwealth argued its case, and they were relevant to the late disclosure of the rapes and indecent assault and batteries that were occurring in the household. The trial judge also correctly ruled that those prior bad acts, the probative value was not outweighed by their unfair prejudice to the defendant, because the defendant, and this also goes to the Dorville instruction or the absence thereof, he was not charged with any disciplinary, he was not charged for any disciplinary actions that he did to his children. The hand on buttocks, which contrary to what my brother just said, there was evidence at trial in that respect. It's on page 155 of volume 3 of the trial transcript, when the Commonwealth is asking, were there any times when his hands touched any other parts of your body? The victim says, he'd really, my butt, like my like butt area, but yeah. So
Let me interrupt you, where the Commonwealth has introduced abundant evidence of prior bad acts and of punishment levied by the father or by the defendant, why not provide a Dorval instruction?
Your Honor, with respect to the abundant evidence, just to make a very quick point about that and then to respond to your question, the direct testimony of the victim in this case, it's pages 96 through 176. That's 81 pages. The testimony about punishments is from pages 110 through 129. That is less than a third of what she was saying. Just going also to the opposing counsel's argument about how it could have overwhelmed the jury. But as to the Dorval instruction,
I didn't say it was overwhelming. To be clear, having read through the transcript, I think it's accurate to say that there was abundant evidence of prior bad acts introduced in this case. I didn't say overwhelming. So,
I
so
appreciate
I'm
that.
going to ask you, for purposes of answering this question, to accept the predicate, even if you disagree with it, that there was abundant evidence of prior bad acts admitted into at trial. So why not? What would be a reason for not providing a Dorval instruction, which I think essentially the defendant is saying, look, I want the jury to hear that you've heard evidence of prior bad acts, you've heard evidence of punishment. It is not a crime by definition to levy punishment against a child. And you cannot take that into consideration when determining guilt or innocence. You have to determine whether or not the specific acts alleged occurred or not, and whether the Commonwealth proved that beyond a reasonable doubt. What would be incorrect about providing such an instruction in a case like this?
Your Honor, just with respect to the last part of instruction that you said about how the jury could not have considered that for any purposes other than to determine the nature of the relationship between the victim and the defendant, that instruction was given at trial. It was given contemporaneously with the testimony of the first victim. It was given in the final charge as well. As to the Dorval instruction that the defendant proposed, the reason not to give it is because it would have simply confused the jury. The prior bad acts instruction, which was given by the judge, it was sufficient for those purposes. And the Dorval instruction that would simply say that the Supreme Judicial Court has determined that, according to Dorval, if the punishment does not cause major harm to the child and all those other factors, then the punishment is legal. That would have merely been confusing because, again, that was not the issue that the jury was presented with. Furthermore, the Dorval instruction would have actually once again turned the attention of the jury to the disciplinary practices, which, if they found both victims believable, they fall nowhere near within the ambit of the permissible parental discipline that the Supreme Judicial Court was discussing in Dorval. Because the first—
Why do you say it's confusing? I'm not sure I agree with that. I understand it may not be an abuse of discretion, but why would that have confused the jury? Wouldn't it have been a reminder to them again, in effect, don't punish the defendant because he punished his children, in fact?
And they were told twice to do just that, Your Honor, not to punish the defendant for, in your words, so for the fact that he was allegedly punishing his children. It would be confusing, Your Honor, the Commonwealth submits that, again, Dorval concerns, it's a narrow instruction on a narrow question of law, as any instruction is, and that is the legality of parental discipline. The legality of parental discipline was not an issue in this case. The defendant was never charged with for any conduct that was related to the parental discipline that he was administering to his children. So instructing the jury on that, it was unnecessary. It would have been confusing, and the judge definitely acted within the parameters of reasonable alternatives when she decided not to instruct the jury as such, and therefore she did not abuse her discretion in that respect. As to the quotation from the Bible in the closing argument, again, that was not supported by any fair inference from the evidence, and the judge did not abuse her discretion when she declined to give the counsel the opportunity to cite that specific biblical verse while allowing him to make a general argument about the adherence to the religious principles and setting the boundaries within the household.
Let me ask you some questions about that. If counsel, without mentioning the Bible, just said, spare the rod, spoil the child, that's okay?
I do not know, Your Honor. If that has very strong sort of, if he is quoting the Bible without saying that he is quoting from the Bible, I would think that that would still be not permissible, because if that verse is immediately recognizable as a biblical verse, then I do not think that it is permissible in the closing argument to make to recite that quotation by not saying that it is from the Bible. But here the counsel did say, I would like to read.
Why is it illegal or unacceptable to quote from the Bible in a closing argument? Just in general. I understand here it's being connected to the mother, it's different, but why can't you do that? What's wrong with that?
Your Honor, again, in this case, the counsel specifically said that she would be quoting from Proverbs 13:34, if I'm not mistaken. So he was giving the jury a clear biblical reference. And I think that would be just unfair appeal to some sentiments that some of the jurors may have about those things. It will be unfair appeal to sympathies of the jury. Unless the court has further questions.
Well, I don't know if it's a question or a comment, but if saying it's improper to use euphemisms or sayings, whether they are ancient sayings, biblical references, I'd suggest to you that if that's facially inappropriate, then there are a number of Commonwealth cases that we see, a number of Commonwealth closing arguments that we may need to take a second look at.
I appreciate that, Your Honor. And my argument obviously is confined to this specific case in which, again, the counsel was attempting to make a very specific reference to the very specific biblical verse, and the judge quite appropriately told him that there is no evidence that the parents were actually bringing up those children, their children, in accordance with that specific biblical verse, so that it was not a fair inference from the evidence that could be argued before the jury in this closing argument. So it's not so much about those general, it's mostly about the general rule that any statements that is made in the closing argument must be connected to, must stem from the evidence, from the fair inference from the evidence. And I don't think there was a fair inference from the evidence that the defendant and his wife, yes, the wife testified that they were in the church, they were in the Christian church, but that does not compel the conclusion or make a reasonable inference from the conclusion that they were raising their children in accordance with the specific biblical principle. And again, the judge did allow defense counsel to make a general argument about setting the boundaries and adherence to religious principles. So the defendant is, not only the judge did not abuse her discretion, the defendant wasn't even prejudiced in that respect. As to the issue,
can you walk me through, assuming you think it, how the evidence of the rape of the daughter would be admissible in a standalone trial on the molestation of the niece?
Yes, Your Honor. So the Commonwealth, as the judge did primarily, the judge was, as apparent from the transcript, was relying on Commonwealth against Gannon, where there was the testimony of two relatives of the defendant, one of whom testified that she was having sexual intercourse with the defendant, I believe, from the ages 12 to the age of 14. And then the second child also testified that she had a single sexual encounter with the defendant, I believe in the form of oral sex, sometime later. So the similarities, and in that case, this court held that the joinder was not prejudicial because there were related offenses. And here, the judge definitely did not abuse her discretion when she determined that the time, the location, the modus operandi, the victim's age, the victim's gender, the victim's relationship to the defendant, the way in these offenses were committed by isolating victims in the defendant's room.
This is really important. Can you just, again, a little slower, this list you're giving me?
Oh, so my apologies, Your Honor.
Write it down.
So in that respect, the trial judge did not abuse her discretion when she determined the offenses were related. She also did not abuse her discretion that some evidence would be, that the evidence would be admissible in the trial of one, the evidence would have been admissible in the trial against the defendant with one victim, and then in the trial against the defendant with the other victim.
You were listing a bunch of similarities.
Correct, Your Honor.
You got down age, gender, relationship, and then I couldn't keep up. If you could give me the other similarities you had.
Yes, Your Honor, the modus operandi, the way in which the crimes were committed, which was the sort of isolation of the victims in the room, the defendant's bedroom, and then the acts of molestation that occurred in those rooms. And also the time, because if the court looks at the timeline, the offense against, and again, just to make it clear on the record, the touching of the breast with respect to the second victim, that was not the only thing that the defendant did, because that victim also testified that the defendant did send her the picture. I believe she testified of his private parts, which was his penis. So he, my apologies, Your Honor, he did not send that to her. He showed her the cell phone, and so that she could see that photograph. So there really is a pattern there in which the first victim, she is starting to, the abnormal nature of her relationship with the defendant starts dawning upon her, and she's starting to reject him. And approximately at that time, the defendant is starting to, quote unquote, grooming the other victim so that he could continue his pursuits. So in those respects, Your Honor, I think the trial judge acted, and again, relying on Gannon and all other cases that she cited in her rather detailed findings that she made and which she dictated into the record, I think she was well within her discretion to join these trials. And then finally, I understand that I only have 30 seconds. The defendant's argument as to double sentencing and double jeopardy, I think it misapprehends either the record or the law, because rape of a child by force and rape aggravated by age difference are not sentencing enhancement. They're separate offenses, and one is not lesser included offense of the other. So it was permissible to sentence the defendant on both, which the judge did. Unless the court has any further questions, the Commonwealth will rest on its brief.
Seeing none, the case is 0453, representatives of the estate of Sherman Starr versus Kenneth Wexler and others. We will hear first from counsel for the appellant, cross appellee, Attorney Rosenthal.
Good morning, Your Honors, and may it please the court. Stephen Rosenthal, representing Kenneth Wexler in this matter. Today we are asking this court to reverse the trial court judgment that was issued against Mr. Wexler and to dismiss all of the claims that have been raised against him. The trial court erred in ruling sua sponte that Mr. Starr had received a completed gift from Mr. Wexler, which imposed a fiduciary duty on Mr. Wexler, and also erred in ruling that Starr's claim for breach of that fiduciary duty was not barred by the statute of limitations.
Didn't Wexler testify that this was a gift?
Yes, he did, but it wasn't a completed gift. And the court relied on the Schlichtstein case, which is cited in the brief and cited in the judge's decision, but the judge only told half the story. He said there has to be a conveyance of an item to the donee, but what he didn't say, and what the case holds, is that the gift has to be delivered in such a manner so that the donee receives dominion and control over the asset during the life of the donor. that was not the arrangement that occurred in this particular case.
I mean, how much more dominion control could you have over a 1/3 interest in KNW than a document proving it and getting the money from it?
Well, the document didn't state when distributions were supposed to be made, didn't say how often, didn't say when accountings were supposed to be made. And the notion was that Mr. Wexler was holding that asset to be distributed at his discretion.
Well, what of the fact that 15 years after the gift was made, Wexler puts in writing, quote, "Sherman, you are not Stanley's partner or partner in the association. You have a piece of my share." And add to that the fact that Wexler testified that he tried to, and in his view, had bought back or bought out Starr of his share. Doesn't that tend to suggest, or doesn't that tend to contradict your argument?
I'm not sure I agree with the way you phrased the last part of that question, Your Honor. I don't believe that Starr bought back the
No, that Wexler testified that he had made arrangements to buy out Starr.
there was an offer.
That said we had a deal and Starr reneged on it. Why is he trying to buy out something that, according to you, wasn't Starr's to begin with?
Well, I believe Mr. Wexler testified that he felt that this was something done out of a moral obligation for Mr. Starr, who he viewed as a surrogate father. And at a certain point, he felt that he had done enough to repay Mr. Starr for the kindnesses that had been given over the years.
But isn't that a question of fact? I mean, the judge had to resolve a number of issues and a number of representations here. I'm trying to discern how the judge's findings are clearly erroneous on that issue.
Well, I think this kind of leads over into the second argument that I want to make, which is that the claims was barred by the statute of limitations. The very note that you're referring to, where Mr. Wexler writes to Mr. Starr and says, "You are not Stanley's partner. You are not a partner in associates. If you have any problems, direct them to me." This was in 2001, I believe. And that is exhibit number 1 on page 70 of the appendix. And the following year, Starr retained counsel, Pasternak, Blankstein, and Lund, to write a demand letter to Wexler saying, "We're entitled to accountings and we're entitled to damages that have accrued since the last time you paid anything." Starr, that was the only demand that Starr made between 2002 and 2015 and did nothing in the meantime. My point is that contrary to what my brother has argued in the Starr's briefs, the notion that Starr's interest, whatever he thought it was being interfered with, came home to him in the years 2000, 2001, and 2002.
Why is that true? Starr isn't getting money, but what would make him think that Wexler had canceled his 1/3 interest in KNW?
Wexler said, "You are not my partner." He also said in his letter of
In 44 St. Paul.
Yeah, but
yes,
you do have an interest in KNW. I mean, that letter confirms there's an interest in KNW, just no interest in St. Paul. So what would make Starr think that his interest in KNW had been canceled back then?
Well, I believe if you look at the complaint and arguments made throughout the trial, Starr was presenting himself as a partner in associates, which was the basis for his claim that he was entitled to profits. The notion that he could not receive anything, that in fact in 2000 he was notified by Wexler that, look, I'm going to be charging management fees, which in his 2016 complaint, Starr said was improper. Well, that I think would bring home to Starr the notion that his rights, whatever rights they were, whether it was in the partnership or in KNW, was something that was being interfered with. And yet he took no action. He took no action in response to, the lack of response to his lawyer's demand letter, when the lawyer wrote to Wexler and said, you owe accountings and you owe money. That was in 2002.
I'm not following why someone saying, I'm going to deduct a management fee would tell you you didn't have an interest. Doesn't it tell you the opposite? You still have an interest, but now a management fee is being deducted from your payments and that interest.
Well, the management fee is something that Starr claimed in his complaint that was unreasonable, and he was trying to undo that. So if that's something that he knew about in 2001 or 2000, then that's something he should have acted upon well before 2016.
Here's what I don't get. If I've got a trust that my nephew is the trustee of, and I'm a beneficiary of it, and I learn my nephew he's incompetent, he's making crazy investments, stupid investments, but he's my nephew, I'm going to let it go. So I can't raise that claim after the 3 years pass. But if my nephew 15 years later says, oh, you don't have an interest at all in this, I've taken your interest, why am I barred from making that claim at that point? Just because I knew he was breaching fiduciary duty in some way, why does that mean that any future breach of fiduciary duty in a different way is time barred?
Because the initial breach, if that's what it was, is what alerted or should have alerted the plaintiff to the fact that his rights were being interfered with. And the case law is pretty clear that he doesn't have to wait until the full extent of his damages are clear or clarified, that he has to take action once he knows that his rights are being interfered with.
Well, let me come at Justice Ditkoff's question a little bit differently. And for purposes of this question, let's assume there was a fiduciary relationship. I know you can test that, and we can talk about that in a bit. But why can't it be the case that there was a breach of fiduciary duty when Wexler imposed the management fee, but no action having been taken within the time period the statute of limitations ran, so that claim is gone? There was a breach of fiduciary duty regarding the, let's call them, if not annual, the periodic distributions. And there was no claim brought timely to continue to receive those, so the statute ran as to that issue. But yet there was still no actual knowledge on the part of Starr that his 1/3 interest was ever in jeopardy. So the statute did not run as to that ownership right until 2014, when we don't need to get into the details, we all know the facts. Why can't we reconcile the judge's findings with the scenario that I just laid out?
Well, I disagree with the basic premise, Your Honor.
Again, assume there is a fiduciary relationship. Go ahead.
Assuming, but not admitting, that there was a fiduciary relationship, the breach of that fiduciary relationship took place years and years before Starr brought suit. And he was still claiming in 2002, I'm a partner, and he was being told, no, you're not a partner. It's hard to think of a more direct or contradictory statement that would tell Mr. Starr that whatever rights he was trying to assert were in jeopardy.
Assume he was telling him you are not a partner in 44 St. Paul's, but he was still either a partner or had an ownership interest in KNW nominee group.
Well, what he said,
Being
what
Starr.
Wexler said was, you have a piece of my share. This goes back to the issue as to whether there was a completed gift or not.
Okay, assume that we have a completed gift also for purposes of my question. So assuming that there's a fiduciary relationship, assuming there's a completed gift, and assuming that the partnership is not in 44 St. Paul, but was a reference to KNW nominee group, did the scenario that I just lay out, is that consistent with the judge's findings?
I don't think so, Your Honor, because if you take that argument to the logical extreme, then let's assume, as long as we're assuming things, that Starr did not bring suit in 2016. In fact, in 2014, apparently he conveyed whatever interest he might have had to the Starr Trust. Unfortunately, Mr. Starr is now deceased. I think it's fair to assume that Mr. Starr's sons, grandchildren, perhaps even great-grandchildren, are beneficiaries of that trust. What's to keep any of those parties from waiting until 2040 and saying, well,
Well, there has to be a triggering event. And I think the judge found the triggering event to be in 2014. I think I have the date correct. 2013 or 2014, when Starr was for the first time told, you don't have anything.
I believe that the triggering, just to try to clarify, I believe the triggering event found by the judge was actually Mr. Bixby's letter of 2015. I believe it was June 1st. And that was the demand, similar to the demand that was made in 2002 for accountings and payments of profits. And there was no response to that. And that was what precipitated the lawsuit. So I don't see how that scenario is any different than what went on in 2002. There was a demand made, there was no response, and there was no attempt to enforce the rights that Mr. Starr thinks he might have had.
Isn't one difference that in 2001, Wexler wrote that you have a 1/3 interest? Deal with me.
I don't mean to go around in circles, Your Honor, but again, if he has a 1/3 interest and the document that codifies or represents that 1/3 interest is not the kind of document that can be considered a completed gift because it doesn't convey control and dominion over that piece of Wexler's share, then it's not a completed gift. So no fiduciary duty could have been created. So we've assumed this and this and this and this, but we have to go back to the beginning and say, was there a completed gift? And I think the case law is pretty clear in this case that there was no completed gift. And again, at the risk of repeating myself, because Starr never had dominion or control over a share of the partnership or a share of KNW.
What would dominion and control look like? I mean, my father's given me shares of stock and I get dividends, but that's all I got. I mean, I get statements every once in a while, but I mean, what do I need to actually have a completed gift there and have dominion and control over my share of Danaher Corporation?
I just note that my time has expired. If I may answer.
Oh, yeah.
We're going to give you more time.
Thank you.
Go ahead.
I would refer back to a case that was cited in my brother's brief, this ILO decision from Superior Court. The late Justice Gantz was a Superior Court judge at the time. And the difference between this case, the present case, and that ILO case is that in ILO, the plaintiff had a guarantee written into whatever instrument that there was, that he was to receive benefits every year. A guaranteed bonus was to be paid every year. There's nothing in the KNW document that indicates that Starr is supposed to receive anything at any time.
But he has a 1/3 interest. I mean, how do you get dominion and control over an intangible share of something?
Well, again, I would suggest that all of the cases that I've cited in my briefs, and I believe they're pretty extensive, that talk about what constitutes a gift that can be considered a completed gift has to be some sort of negotiable type of instrument, something with intrinsic value. Mr. Starr could not have taken the KNW document, walked into a bank and say, look, I offer this as collateral for a loan for $1 million because someday I'm going to get a piece of this share.
You're made a beneficiary of an interest in a trust. There's no way for that gift to be final and completed. I mean, it's not a negotiable instrument.
It depends on the terms of the trust you're on. I mean, any trust properly written would indicate when the trust expires or when, at what rate distributions are to be made or what's to happen when the trustee or the beneficiary dies. None of that happened in this particular case. I would suggest that it was Mr. Starr's burden to prove what that document actually meant. And I believe that if you look at the face of the document, it is totally unclear as to what the nature of the gift was in terms of when it's supposed to be paid out, how it's supposed to be paid out, how it's supposed to be quantified.
By that document, you mean the KNW nominee group acknowledgement?
Yes, Your Honor.
Okay, and the judge struggled as to a determination of what it was. At one point, I think he might have said, this might be in the transcript, it's akin to a partnership, but did he actually make a finding as to what the document specifically was or was not?
No, that's why he called it a completed gift. There was no partnership agreement. There was no partnership in the sense that Mr. Starr participated in the operation of the partnership. He certainly had nothing to do with the operation of the condominium units. So no, I don't believe the judge said, and correct me if I'm wrong, I don't believe he said it was akin to a partnership. What I said in my brief is that this arrangement was akin to a corporate freeze out, and I cited cases which indicated that the corporate freeze out, it basically gives rise to a fiduciary duty. There's a triggering point, and at that point, it doesn't matter how far out the damages might extend.
So am I correct in thinking you don't believe there can be such thing as a silent partner in a partnership? That if
there can certainly be.
Everyone has to be participating in the management of the business, or they're not partners?
No, I don't agree with that, and I accept that. In this particular case, however, A, there was no partnership agreement. B, if Mr. Starr considers himself a partner, then he didn't comply with terms in the partnership agreement of the associates, which state in part, I believe it's at page 96 of the.
He's not a partner of 44 St. Paul. He's a partner of KNW.
Well, he's, again.
If he's anything.
Mr. Wexler.
There's no way he's a partner. I should phrase it differently. There's no way he's a partner in 44 St. Paul Street. If he's a partner in anything, it's a KNW.
Well, again, Mr. Wexler said you are not my partner in the associates. You own a piece of my, you have a piece of my share. If there's a problem, come talk to me. And he didn't come talk to him.
So
if there are no other questions, Your Honors, I will rest on my brief.
excellent. Thank you very much. We threw a lot of questions at you. That was well argued. So we will now hear from Attorney Bixby.
Thank you, Your Honors, and may it please the court, Brian Bixby representing the plaintiffs, the appellees, cross-appellants, who are now the personal representatives of the estate of Sherman Starr. Sherman was present and did testify during the trial, but he died subsequently. As to what Starr owned, the court got it right. In terms of what we are asking the court to do here, one is to reverse the accounting to require 6 years of accounting at least, to reverse and remand on the conversion count, and to remand on the breach of fiduciary duty for further findings of breaches going back to 2000. That's the primary focus. And in our brief, we did talk about some procedural flaws in the appellant's brief and approach. I'm not going to spend our time on that. That's covered in our brief. In terms of whether Starr's interest survived his death, the trial judge properly found that there was no evidence whatsoever of any lifetime limitation. It's very clear that we're talking 16.67% of something, and your honors have pointed out it's certainly not a piece of real estate itself. It's part of the KNW group.
Let's go to statute of limitations to start. I don't want to repeat the entire premise. You heard the questions that I asked of Attorney Rosenthal regarding the scenario that why couldn't there have been two breaches of fiduciary duty? Again, regarding the management fee and regarding the right to receive periodic distributions that are barred by the statute of limitations, but then a subsequent breach in 2014, 2015, regarding the 1/3 interest in the nominee group in KNW. Why isn't that consistent with the judge's determination?
That certainly can be consistent with the judge's determination. And it's that last breach of fiduciary duty that then opens the door to saying what we need to know and do to resolve that latest breach of fiduciary duty is to know what happened previously for which there were no records produced.
So assuming that's correct, why wouldn't, I understand that's why you need the accounting. Why was the judge incorrect, according to you, in limiting that to 3 years, the 3 years preceding your client's bringing up the cause of action, I believe?
Well, if you look at it solely as a breach of fiduciary duty and that particular breach.
Yeah, let's put conversion aside for purposes of that question.
And you can argue strictly the 3 years, but it's a question of when it starts to run. And it's an actual knowledge thing. When did Starr have knowledge that there was a breach of fiduciary duty?
Right, but once he has knowledge, again, the judge found a date by which he had reportedly had actual knowledge, and he limited the recovery period to the 3 years, to the 3 preceding years, if I'm not mistaken, correct?
Correct.
Why is the judge incorrect in doing so is my question to you.
The reason is because you can't look at that in isolation. I do think that you can't ignore the conversion aspect of it as well. And in addition to
there's no conversion for purposes of the question, as I just said.
Okay. Well, then
we agree the judge got it right by limiting it to the 3-year period.
There is a 3-year statute of limitations on breach of fiduciary duty. That is correct. However, now we take away your hypothetical where you ignore conversion. And
neither you nor Attorney Rosenthal like my assumptions. I understand. There is a method to this. Thank you.
But a part of our appeal is that these are not mutually exclusive and that you can have a finding both a breach of fiduciary duty and conversion. And you can also have a finding and should have a finding of a continuing breach on continuing toward analysis and conversion of each year, because you correctly raised the issue of what type of entity are we dealing with? Well, no, it's not a partnership. It's not an interest in real estate. It's a co-ownership. It's an entity. That's what that Exhibit 25 is, signed by WEXLER saying, here it is, you have 16.67% and I do as well, and so on. It's the same as when somebody inherits something. And let's say, to use Judge Ditkoff's example, you have a nephew, and you have a nephew, an uncle, and aunt, and they all inherit something, and they each own a 1/3 interest in it. Well, that doesn't make them partners, and it doesn't make it a partnership, and it doesn't make it a trust. It's just an entity that they co-own, and they each have their own interest and their own duty. Now, in this one, Wexler took the role of the manager, and he says, this is my share, you have a piece of my share, and then at one point he's saying, and I'm charging you a management fee for this, and I'm doing it retroactively for 15 years. So he's assuming the role of the manager of this entity in which he admits that Starr has an interest in. And
I mean, that's April 10th, 2000. Wexler says, I'm opposing this management fee that effectively cancels out your balance. So why doesn't that put Starr on notice that his interest in KNW is in jeopardy, is basically being canceled?
Is nowhere that it says that it's being canceled. It's the opposite of that. It says you have a continuing interest.
If they're going to put in a management fee that effectively cancels, that's what the judge found anyhow, that effectively cancels out what you get. How is that different from you don't have anything?
I don't think he says that it cancels out what you get. Remember, Starr has an interest in the entity. The income stream is just part of that. Even if this property produced no income whatsoever, that doesn't change Starr's 16.67% interest. As a matter of fact, it's very common in entity, whether it's commercial real estate or anything else, that it doesn't always produce net income for distribution.
That makes sense, but if that's true, then why does he have a live claim in 2016 for anything other than his equity interest? Why does he get to go back and ask for these annual payments that Wexler made it very clear he wasn't going to give anymore back in 2000?
Well, I don't read it that way. And a management fee certainly can't be more than 100%. So a management fee is generally in the real estate world, 5 to 10% is a management fee. So that, and it's coming out of income. So I disagree that there's any finding or any conclusion that there was going to be no further income produced by this. But even if there weren't, owning an interest in an entity that owns a piece of real estate is a good investment, even if it produces nothing, because as in this case and just about anything, the value of that goes up substantially and has gone up substantially.
No, I get that, but the judge also seems to be saying the last 3 years of income from March 25th, 2013 have to be figured out and paid over. Why hasn't the statute of limitation run on that? Let's say you still got your third equity interest that you can do as you like with. Oh, why is the judge right to give you the last 3 years of income?
Well, because certainly that's both the law and it's reasonable to determine. This is why we have a statute of limitations, and it is limited in the fiduciary range, which is different than the contract range. Because again, and I understand you're isolating that issue on fiduciary, but I'm saying as a matter of reality in terms of what it was also a contract arrangement. And that has, number one, a longer statute of limitations. So you can go back further. And we also have, as a reality, the continuing tort analysis of a conversion where it is renewed each year. So I think as a matter of law, equity, and fairness in those multiple grounds, it is likely that we can go back and just see what was done. There are accounting records. It's just a matter of seeing what's there. And if in fact Starr was entitled to a share of that, it's easy to calculate what that is. Because he still, and it's undisputed in my view, he still owns that 16.67% of the underlying interest.
For your continuing tort theory, are you relying, your best case is the Aiello case by Chief Justice Gantz out of the Superior Court?
Yes.
Okay. And as I understand it, if you also succeeded on a conversion claim, you're saying that it would push the statute of limitations back, or your collectible period, if you will, back an additional 3 years. Is that correct?
That is,
What is your best case? And I understand it's a fact-intensive inquiry, but what is your best case for the proposition that the relationship that existed here between Wexler and Starr was a fiduciary relationship?
it's a fiduciary relationship because of, again, primarily Exhibit 25, in which Wexler says,
No, I understand what the factual arguments are. My question is, what is the best Massachusetts case from either our court or the SJC that suggests that there is a fiduciary relationship in circumstances like these?
I really couldn't limit it to one case. We've cited many. I couldn't say that one is more than the other. Fiduciary relationships are very common and very strong in every type of situation. And I've heard the word trust mentioned, and this is not a trust situation. But whenever you hear the word nominee, again, that's also an idea. What responsibility does the manager owe to the people who have an interest? Is it a fiduciary responsibility? I would say it is, and that's the way.
Is there a case that says that? Is there a case that says that whether it's a nominee trust or just when you see that nominee status is tantamount to fiduciary relationship? Because I don't think I've seen one, but that doesn't mean it doesn't exist.
Well, you're correct, and I could supply you with cases on that. We do a lot of that in the probate court. This was a Superior Court case, but it comes up all the time. If I may continue, Your Honor.
Please.
Thank you. We also heard this idea as to whether or not this interest was a completed gift. I maintain it certainly there are the gift aspects to it, and as justices have determined and alluded to, there's no other way of a person who owns a minority interest in something to exercise dominion and control other than what has been done. But it was also more than just a completed gift, because you also have to remember the evidence that Mr. Starr purchased this interest. He paid Wexler at least $30,000. And we say that was also for purchasing this interest. And then you also have to remember that Wexler did admit to paying Starr over $100,000 in profits on this. So we have plenty of evidence as to what it was, whether you call it a gift or a purchase. It was completed. It was not limited to lifetime. And as we continue to go forward, Starr continues to have rights in that.
Could I ask a quick question on the I'm sorry, have you finished your answer to Justice Neyman's question? Could I ask a quick question on the conversion? Can you just confirm what Mr. Starr's position was on what was being converted and what the damages were?
Yes, what was being converted was his 16.67% interest in an entity that owned income-producing real estate. And so, number one, when Wexler refused and failed to continue to distribute Starr's share of the income, that's a conversion. But also when Wexler finally seemed to say at some point, and now you don't have any interest at all, that's a conversion as well. So there was one conversion in terms of rights to a share of the income from the property, and another conversion of failure to acknowledge the continued 16.67% interest. And keep in mind, Your Honor, that during most of these years, Starr continued to file tax returns reflecting his interest in this, and that Wexler was in possession of K-1s that indicate the interest in the property.
Where does it say that I was looking for the K1 evidence in the transcript, and it seemed to me that this accounting firm had all the K1s. Where do we have evidence that he was actually putting in the period after 2000?
Yeah, that's exactly it.
Yeah, I'm looking at the trial exhibits of K1's trial exhibit 27, 28.
Can you tell me where that is in the record? That they aren't listed by exhibit number, so.
Yeah, Your Honor, they're not part of the record appendix. They're part of the transcripts, and they're discussed in the transcripts. Our principal brief on page 19 goes through and describes all of the exhibits that are not part of the record appendix.
And weren't some of the K1s only admitted for a limited purpose, or am I misremembering that?
You're remembering correctly, Your Honor.
I mean,
So that limits the scope of our review of them, correct? Consistent with whatever evidentiary value the judge gave.
Correct, Your Honor.
it seems to me if you want us to rely on these exhibits, you're going to need to put them in an appendix and let us see them.
And we're not asking you to rely on those exhibits.
Okay.
Your time has expired, Attorney Bixby, but I did give Attorney Rosenthal additional time. If you would like to sum up or address one more discrete issue, please feel free. Otherwise, you may submit it on brief. Go. It's up to you.
I don't have anything else to add. As I said, I think the trial court got this right in terms of what Starr owned, and now it's a matter of determining what to do next in terms of what he's entitled to for what he didn't get within whatever period is open, and then
We are live and on the record.
Calling our next case, docket number 2021 P0489, 21st Mortgage Corporation versus Bruce DEMUSTCHINE or DEMUSTCHINE. Counsel will please clarify for me. We will hear first from counsel for the appellant, Attorney McArdle.
Thank you, Your Honors. Good morning and Happy New Year. Attorney Luke McArdle on behalf of the defendant appellant, Bruce DEMUSTCHINE. I think it's easy to get lost in the confusion and convoluted history of this case when we're before you, I think, on a very simple question. And that is first the standard regarding the abuse of discretion and clear error of law. I think the question before the court, the simple question to be focused on, not that it's simple to interpret, but the simple question is whether an interim use and occupancy payment pursuant to chapter 239, section 5 and 6 can be imposed against a post foreclosure litigant appealing a judgment for possession when possessory rights to the subject property, which is a single family, have not been obtained against another recognized legal occupant of that property.
Let me stop you right there. Oh, sorry.
Okay, go ahead.
No,
Go ahead.
Chan, please.
My question, Attorney McArdle, was going to be, can you update us on the status of the summary process proceedings against Valerie Devine? Are those matters still pending? Is that matter?
Yes, it's still pending dispositive motions, summary judgment motions submitted by each party.
And I had two preliminary questions as well, and that's, I think I know the answers to these, but did Devine ever move to intervene in this case or have any involvement in this particular case?
No, none whatsoever.
Okay. And I think, did she file an affidavit stating that she occupied the property?
Yeah, this was during just the bond evidentiary hearing regarding, trying to figure out what the interim use and occupancy or waiving the bond was going to be. Just filing that said that she had been living there for 20 years. They've been, a long-term relationship since before this mortgage was even originated. So it's not like she just moved in there trying to sneak in and do some type of shady business where they're trying to extend possession of the property. She has almost an ownership claim, and I think she might even have a survivorship ownership claim that's not otherwise part of this record. So it's not like she's just a tenant or someone in possession. She has a serious interest in this property as well.
That sort of dovetails with my last preliminary question, which is this, and I think you were just talking about this in sort of your opening statement. At page 19 of your brief, you state an appeal bond and or use and occupancy payments are not applicable or allowable in a summary process case that does not result in complete possession being granted to the plaintiff, as is the case here. And my question for you is, what is your authority for that proposition?
The case law is severely limited on either side to support it. I think this is an issue of first impression, to be honest with you, Your Honor. We've searched and there's nothing specific to this point. I think we just have to do a full interpretation of the intent and the application of 239 section 5 and 6, which I've had the pleasure of doing in the King case. And so I would say I know as much or more about the history of chapter 235 on 239 section 5 and 6. I mean, it's lengthy. It's a statute that's been around for 130 years. And if even going back to the first acts of 1888, which is when it was first enacted, the language regarding this aspect of the case has all but not changed at all. It's almost the exact same in 1888 as it is today. And the applicable part of section 5 is 5C at the end regarding the use and occupancy payment is, quote, all damages and loss which he may sustain by reason of the withholding of possession.
Yeah, you skipped the first part, which is a reasonable amount as rent of the land. You skipped that part and went on to the end part.
Right, because the end part applies directly to the interim use and occupancy payments is what I'm trying to get to. In my assessment of the statute.
The statute seems to say, if the action is for possession of land after purchase, the condition of the bond shall be entered to the action, the payment to the plaintiff, if final judgment is favor of all costs and of a reasonable amount as rent of the land from the day that the purchaser obtained title.
Yes, that's applicable to the bond, in my opinion. The bond, and then it can be a bond, the bond can be waived, and there can be a bond. In addition, there can be use and occupancy on top of a bond. And we're at the point where the bond was waived in this case, and the only thing applicable at this point is interim use and occupancy payments during the pendency of the appeal. So that's why I just jumped to that specific section, because that's directed to the interim, in my opinion, in my reading and understanding of the statute, is the direct application regarding the interim use and occupancy payments applicable to the appeal. And the plain reading of that is that possession, an immediate legal right to possession is necessary. I think if we look at this in a practical view and the intent, and you look at a tenancy by the entirety, there's some bad business practices that we've seen with the mortgage lending practices where you give a loan out to a husband and not the wife, even though they're both on title. It's not good practice, but it's legal and it can be done. Just in this case, if someone brings a possessory claim after a foreclosure and tries to get possession over a husband, even though a wife is on title as well, you can't then say, well, the husband needs to pay use and occupancy payments during the pendency of an appeal when the wife has possession of a single family property and the husband can maintain possession under the guise of the wife. It just, in practical terms, it doesn't make sense.
You're assuming the conclusion. I mean, if you were a landlord and you had two tenants, you could evict one of them and not the other one. And if that one didn't want to go, we'd have to pay use and occupancy while he's on appeal, right?
I think it depends on the facts and the scenario in the case. If it was a single unit, if it was a multi-unit you're evicting a tenant, I don't think it makes much sense to evict a single tenant if they're in the possession of the same unit or under the same lease agreement. I think
it's not good practice, but obviously the plaintiff here is evicting the occupants one by one. It would have been a lot more efficient to evict them all in one proceeding, but why can't they do it one by one? And as each one comes, if they want to appeal, they got to pay use and occupancy. I mean, what happens when Divine gets evicted? Does she not have to pay use and occupancy because your client has the right to possession until the appeal's done?
Well, yes, I think the statute is specific to the damages. It specifically says the damages and losses that the plaintiff may sustain for withholding of possession. And the damages would be collecting rent from a third party, selling the property, but the plaintiff in these cases, in this case particularly, cannot do that. There's no damages because if, say Mr. DeMuschine foregoes his.
So you're saying if both plaintiffs, if both defendants, if both occupants get evicted, neither one can be forced to pay use and occupancy because there's another one of them. Is that what you're telling me?
It depends on the scenario, but to some degree, yes, that's correct. I don't think it makes sense that you could force someone to pay use and occupancy. What if Mr. DeMuschine foregoes his right to possession and says, I just want to appeal this case without, and I'll release my rights to possession of this property? Does he then have to pay use and occupancy during the pendency of the appeal? I just want to appeal, I just want to appeal my rights to this case, and I strongly, and I'll give up my rights to possession.
You seem to be suggesting that if there are two occupants of a property, there can't be use and occupancy ever because there's always the other person.
I think it depends on the facts of the case. I mean, if a tenancy relationship,
Wouldn't that not be the result of your argument?
I mean, a landlord tenancy relationship is much different. There's a contract, there's privity, there's a contract. There's no tenancy relationship between
That's
these two
fair, but
things.
let's just go mortgages. Usually there's two people on the mortgage.
Sure.
If there's two people on the mortgage, there can never be use and occupancy payments because there's the other person.
No. If both were subject to this judgment of possession, sure, because because the plaintiff is entitled to full possession of the property, but for the appeal. In this case, they're not entitled to possession.
When Divine gets evicted, they'll both have to pay use and occupancy.
Correct, but it can't be use and occupancy for the entirety of the property. Each one would pay separate. They would be getting double payments.
They would each pay half, right?
Correct.
So why don't you have to pay half now for your half of the property? Your half interest in the possession of the property.
I think that the point is that there's no superior right to possession at this point.
Well, is there no superior right as between 21st Mortgage and Mr. DeMuschine, or is there? Would you agree with me that?
I would agree with you. Yeah, of course. Pending the appeal, there's a judgment against him for possession. I agree with that. Yes.
Right. So why is then 21st not entitled, based on its superior right of possession as to Mr. DeMuschine, to have that occupant paying use and occupancy during the pendency of his appeal?
Well, I'm just going off the plain reading of the statute is for damages for withholding, and what damages there has to be actual damages. What are the actual damages? If they can't collect rent, they can't sell the property, they don't have full rights to go in there and rent the property and do anything with it. There's no damages.
So despite the benefit, go ahead, Mr. Ditkoff.
It's not what King tells us to do. King tells us to go through and weigh all these various factors based on how long it's been and how many payments have been made and the financial conditions. Nothing in King says in this situation that you go and figure out how much the mortgage company will lose by the delay, which probably wouldn't have much relationship to the reasonable fair market rent anyhow.
Right, I agree.
How do you reconcile this with what we've been instructed to do in King?
I agree that, but the King is under an assumption that, and the truth of King was that they had the full possession of the only occupant of that property. So there was never that element that there's no discussion whatsoever. There's some language in there in King that I could read that even says Section 5C provides specific conditions for a subset of appeal bonds in cases where a plaintiff, at the time the appeal bond is set, seeks to recover possession of land or tenements. Even if execution were provided, they cannot levy on the execution right now. They wouldn't be able to do anything with it. They don't have the right to do it.
I understand why couldn't they evict your client, even if they can't evict Divine?
And they did. A constable will not do it. They have to have full possession of the property and rights to execute on the property. If it's a single family, if it's a unit, if it's a separate unit, a multifamily, and they lived in a separate unit, sure, they could pull them out of that single unit. I think in just looking, even in a situation where tenants are common, or the prior situation I explained with tenants by the entirety, it was a bad decision by the plaintiff not to pursue discovery and ask who the occupants were, even though he'll, contend that this was concealment. It wasn't whatsoever. There's strong claims in this case, and we went all in on the actual strong claims. This was not even a thought that this was not a defense that there was another occupant in the property. This was a sidebar thought once there was a use and occupancy demand, and Mr. DeMustichine did not expect to lose this case. So now that he can't appeal some substantial, not your standard claims in a post foreclosure eviction case, there's some long history where he obtained a significant right. He obtained in 2010 a judgment that said this mortgage is unenforceable and cannot be foreclosed. He obtained an incredible right, and he's
against another entity, and then he sued this entity, and it's stipulated to the dismissal of that with prejudice. I mean, that's.
Yes, there's a lot that goes behind that door, though. There's a lot that we don't see with what happened with his prior counsel and some potential malpractice. There's a lot that like the stipulate. There was no reason.
Let me ask you this: if we decide that it was not proper to issue a use and occupancy for the entire fair market value of the property, but only half, what do we do? Can we review the amount at this point? What would we do with that conclusion?
Yeah, I mean, I think the King analysis is still available to be made, and I do think there was a mistake in that regard regarding the merits of a defense. That it's the way it went down with the trial court judges is unnerving to me. With the decision that was made, the timeliness of the decision after the comprehensive record of submissions, it's incredible. And there were some incredibly inaccurate applications of law regarding res judicata, issue preclusion of a federal court matter. There's so much in this case that just ended in 2 seconds without an opportunity to really seemingly provide the merit. It's a lot. It's not really part of this unless you're going to weigh those factors. But I think the merits should take it even beyond what was applied for a use and occupancy. And if you were going to do half and half and say, there's 2 occupants, they should only be subject to half of whatever the payment is. Sure. I mean, that would provide some.
I guess my question is, what is our scope of review? I mean, if you're right that legally you can't do use and occupancy at all in this situation, that's easy. Then we reverse. But if we're not sure the amount is right, do we review that at all? Do we review that for abuse of discretion? How do we do that?
Right. And the abuse of discretion standard is harder because it's harder to prove that she didn't weigh the factors. There's so many factors, and there wasn't a clear analysis on how they were weighed in each regard. So that's a tougher review rather than the argument that it's a clear error regarding the issue of this issue that really hasn't come before a higher court, and there's really no precedent on. And the single justice did say that that I hadn't cited any case law and that none exists to her knowledge, which is true. I searched intently to try to find some, but there's nothing specific to this arrangement. And I think this needs to be, obviously you guys will have the opportunity to set this precedent going forward, unless it's something that needs to go up to the SJC. But yeah,
Let me stop you right there, Attorney McCarley. Your time is expired, but I have a quick question, which is your brother says that the existence of an additional occupant was not raised as a defense in the underlying eviction claim.
Mm-hmm.
So it begs 2 questions. Is he correct? And if so, what is the takeaway from that?
Yeah, I think that just confuses the issue because it wasn't a defense. It's not a defense. It was part of the evidentiary hearing regarding a bond and use and occupancy, which is a separate. You can bring in separate evidence. You can call in a realtor. It's totally separate. It has nothing to do with it. Having another occupant in the property doesn't raise any defenses that he was going to add or bolster his claims.
You're saying it's a red herring.
Yes, correct.
Very good. Your time has expired, so unless there are any questions from the other justices, and seeing none, thank you very much for your argument, Attorney McCarley.
Thank you, guys. Thanks.
We will now hear from counsel for the appellate.
Thank you, Your Honor. May it please the court, Michael Hagopian, representing 21st Mortgage. the plaintiff and appellee in this case. And Judge Neyman, thank you for bringing up that last point. I'd like to start there. I raised that issue, and even during argument here, Mr. McArdle, I believe he stated that there was no superior right of possession because there was only a judgment against one of the occupants. So by bringing and raising the claim at this point, he's raising that as a defense, that 21st Mortgage doesn't have full possessory possession of the property. That wasn't raised below, and that's the reason why I raised it in my brief. Didn't argue it, didn't raise it, and now, only after the fact, is he raising that as a defense to 21st Mortgage's possession of the property, right of superior possession of the property. And I think that that's very relevant. It's not a red herring.
Wait, but where does it go? He certainly raised this argument in the use and occupancy that because of Divine's presence, that he shouldn't have to pay use and occupancy. So what does it matter that he didn't raise it? Obviously, he can't raise that on appeal, on the full appeal. But what does that matter for our purposes?
Well, the purpose that he's raising it here appears to me is that he's claiming that the judgment that was entered wasn't a superior right of possession. And if it wasn't a superior right of possession, it should have been raised in his case in chief. Otherwise, if it's not a defense and 21st Mortgage does have superior right of possession, then they have a right to use and occupancy pending appeal.
He's saying that you can't get this property right now.
Which I disagree. There's nothing prohibiting the levy of an execution against one occupant of a property when there has been a valid judgment entered by the court.
But even if you accomplish that, you still wouldn't have the property. Divine would still have it. So
yes, but he is enjoying use and occupancy of the property during this time. And the King Court made it very clear that post-judgment, one is not entitled to occupy the property free of paying any value for it. And that was very clear. The single justice noted that in her opinion, and the case was ultimately dismissed. I think if you look at the crux of this case, really what the case is about is the dismissal. And the dismissal of an appeal is jurisdictional, and it's based on 239 Section 5H. And there is really no discretion. The housing court judge was obligated to dismiss the appeal because a use and occupancy order was entered by the housing court judge. And mind you, when we're talking about use and occupancy, if we look to the original decision from Judge Mitchell Munivar, he indicated in his decision that there was a stipulation between the parties that use and occupancy was $3,500. There was no dispute as to the amount. He unilaterally reduced that to $3,000. That was also reviewed by Justice Hanlon on appeal. Before on the single justice appeal, she reduced it to $2,000. So both courts considered the value of the use and occupancy, knowing that Mr. DeMuschine raised the issue of him living with his girlfriend, and both still imposed that use and occupancy amount pending for the appeal against Mr. DeMuschine.
How can that number be right? If the fair market value is $3,500 and he's only one of two occupants, then how could it be more than $1,750?
For the simple reason that was raised, and again, the record really wasn't established. He indicated that his girlfriend lived there with him. Best case from what was presented, she lives there as his guest. There is no evidence in the record that she had any other right. She's not an owner of the property. She wasn't a prior mortgagor. She wasn't a prior borrower. She was there presumably as his guest. Again, it wasn't established in the record. Whatever interest she has in the property, her ability to reside there was never established, and the court really shouldn't read anything into that other than he referred to her as his girlfriend and she was there as his guest. I also want to touch on a point that was raised during my brother's argument, and that was whether Miss Devine intervened. She didn't intervene. And if you look at the record, Mr. DeMachine was served as the former borrower and the known owner of the property. And we also included all current occupants. And the notice to quit was served at the property.
But the judge struck the all current occupants that you can't.
Correct. But she was on notice that the case was pending. And I agree that she should have intervened if she felt that she had rights.
Why in the world would someone intervene as a defendant in a summary process case? Best you could do is get evicted.
Well, she had actual notice of the eviction. She had actual notice of the plaintiff's claim for superior right of possession. If she felt that she had superior right of possession, she should have intervened. She had notice. She was on notice of those claims. Now, from my client's perspective, this isn't a standard landlord-tenant situation. The only persons that my client were aware of were the borrower and the owner of record. Other than that, there's no written agreement between the parties. My client doesn't have the ability to go into the property or otherwise determine who's actually occupying the property at the time that the eviction's brought.
But to your brother's point, you do have, or your client had the opportunity to obtain discovery on that issue and for whatever reason elected not to do so, correct?
It is correct, except the motion for summary judgment was brought by my brother very, very early in the case. Again, he brought it based on the fact that he was relying on the federal court decisions. So this summary process, the summary judgment was brought very early on. My motion for summary judgment was based on cross-claim for summary judgment. Had the case developed, perhaps additional discovery would have been accomplished. But again, from my client's point of view, Mr. DeMachine was living there. They obtained a judgment against Mr. DeMachine, and under 239.5, the judgment is what triggers use and occupancy. And I also want to touch on, one of the issues that was brought up regarding damages. I think the King factors do take into consideration damages because one of the things that it takes into consideration is the taxes. This is a property where there's a little over $11,000 a year in taxes that are due that my client's been paying. Those are clearly damages. They're not being compensated anyway for their payment of both the insurance, the taxes, and any other expenses that go along with the property during Mr. DeMachine's use and occupancy of the property. And these are factors that the court should take into consideration when issuing a periodic payments under both sections 5 and 6. And that brings me to the issue of the decision of the single justice. In evaluating the appeal, it was an appeal of the use and occupancy order. The single justice took all of this into account. The fact that there was another occupant living there, the King factors, she reviewed all of the King factors, and she was also satisfied that the housing court followed all of the King factors. So there was no abuse of discretion, and it's a very high threshold for the appellant to meet in seeking to reverse the decision or the imposition of use and occupancy pending appeal. In this particular case, the courts, both the housing court and the single justice, reviewed all of those King factors and found that use and occupancy was proper. It was only based on that under Section 5H that the housing court judge was obligated to dismiss the appeal on the merits because the use and occupancy orders were not complied with. In fact, this also clearly tracks the SJC's decision in Ajardi. Ajardi was very clear that there is no secondary appeal on a use and occupancy order. Now, the single justice, that is an appeal of right. DEMUSTCHINE exercised that right and did have a full and fair hearing before the single justice. This isn't a tertiary hearing. This is a hearing to determine whether the case was properly dismissed and whether there was an abuse of discretion below. And quite frankly, counsel hasn't raised any issues which show that either the housing court or the single justice abused their discretion in issuing a use and occupancy order.
Single justice issued a use and occupancy order the statute doesn't permit. Isn't that an abuse of discretion?
But the statute does.
We got to figure that out, but yeah.
Yeah, and I think if you look at, and I looked through it, and I see that my time's up, but if I could just finish this thought. If you look at—
You can take 30 seconds to sum up.
Section 5, all through Section 5, it refers to judgment, 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 not execution, not levy of execution, but once judgment issues, that triggers the appeal bond. And, use and occupancy based on rent and damages, and we have all that here. And for those reasons, the decision below should be affirmed and the appeal dismissed. Thank you, Your Honors.
Excellent. Thank you both. Thank you both very much. And the case is submitted.
Thank you, Your Honor.
We are live and on the record.
And good afternoon. Continuing today's appeals court sitting, January 6th, 2022. Our final case is docket number 2021 P0367, King versus ALTHAUS or ALTHAUS. We will now hear first from counsel for the appellant, Attorney Patton.
Thank you, Your Honor. May it please the court, my name is Attorney Edward Patton. I represent the plaintiff appellants in this. The court has reviewed papers and pleadings that have been submitted
Attorney Patton,
by way of
Attorney
briefs
Patton's going to stop
and
you.
by way of appendices. I'll put it. Hello.
Yeah, Attorney Patton, there appears to be a delay on your connection.
A delay.
Yeah, there's a delay, and you were we couldn't hear you for a minute. So what I'm going to do is we'll keep the clock running, but if you could just restart your argument, and if you sit back from the computer a bit, it might help. Let's try that.
Good morning, Your Honor. May it please the court. I am Attorney Edward Patton, representing the plaintiffs' appellants in this action. I've been advised by the court that the justices have reviewed the briefs and the appendices and other papers that have been submitted by way of the record in the context of this matter. Accordingly, I will merely provide an overview of the factual scenario in which to argue the two issues which I have raised on appeal. And those issues are whether the trial judge erred in determining that the appellants were not benefited by the a shared use of the easement in issue here, And if the appellants were not benefited by an express reservation of a shared use by the creator of the easement, then they are benefited by an easement by prescription, which commenced more than the 20-year statutory period ago. Essentially, there were two pieces of property shown on the plans of record, whereby Lot 2 was a piece of land at the corner of Highland Road and Route 6A Shore Road in the town of Truro, Massachusetts.
So, Attorney Patton, let me interrupt you. How was the use exclusive here?
The defendant appellee has claimed that they were entitled to the exclusive use of the easement area. Their position in that respect throughout trial and the motion for summary judgment, which they had submitted about 3 years ago, their position was that because the language of the easement, which was created back in 1985, did not contain any words of sharing of any type, that they were entitled to an interpretation that the easement had granted Lot 2, their property at the time, had granted them a non-exclusive easement over the easement area. So it was, in essence, the pronouncement of the defendant appellees that they were entitled to an interpretation of the express written easement shown on the plan within the papers, that the proper interpretation gave them the sole right to use this easement area for parking, and then my clients had no such easement. My client's position, based upon the case law as cited in our brief, indicates that where there is a co-extant use of an easement, that there is essentially a presumption that unless there is language of exclusivity included within the easement documents, then there is a presumption that the easement is not to be interpreted as granting exclusive use to the dominant.
Counselor, in your brief, I read it as only challenging the conclusion there was no prescription for your clients, not challenging the interpretation of the written easement. So if you think you've argued the interpretation of the written easement in your brief, you need to tell me where now, because as I stand now, I don't think that's an argument in your brief.
Yes, Your Honor. That would be
You know what, Attorney Patton, I want you to make better use of your time. So the brief's going to speak for itself. Why don't we move forward with the argument? And I have a question for you.
Yes, Your Honor.
Which is, your brother asserts that the issue of easement by prescription was not raised in the lower court. Is he correct?
No, he's not, Your Honor. I direct the court to the Record Appendix, Volume 1, page 51, which contains the amended complaint in this matter, which added a count 4. And count 4 was
declaratory judgment, yeah,
was drafted and submitted requesting a declaratory judgment based upon essentially the elements of adverse, I'm sorry, not adverse possession, but prescriptive easement. So the issue of prescriptive easement is certainly within the potential grounds for the declaratory judgment requested in favor of my clients if the court found that the grantor of the easement intended that it be for the exclusive use of the defendant's predecessors and subsequently the defendant.
And am I correct that the easement exists on your client's, what would be your client's property or your client's lot?
The property on which the easement exists is part of the common area of the condominium that my client owns, what is referred to as Unit D of the condominium.
So what about the black letter law that says you cannot have an easement over your own property?
Well, they don't have an easement over their own property. There's an
that you're claiming that your clients are claiming that they have an easement in effect over their own property, is I think part of the argument your brother has made.
My clients are claiming that there was fee ownership in this property going back in history. There was a conveyance in 1985 by the then owner of this property, Lot 4 on Highland Road, that created an easement at that time for parking for the benefit of adjacent property. The property was used in a shared fashion from and after that time. There were several transfers of ownership of Lot 4, being the benefited property. And eventually the property was condominiumized and my client purchased a unit in that condominium. And the condominium did include a common area, which included the easement area. And with all due respect, Your Honor, I do believe that the law is such that one who has the holder of rights in a holder of rights in an easement in a common area is entitled to vindicate those rights as against a third party that prejudices and interferes with the use of the fee rights of persons such as my client.
Counselor Jay Murphy, in his testimony and affidavit, said that for 20 years, there were signs in this area saying parking for Dutros. So if the judge, and I understand there's contrary testimony for sure, well, deposition testimony anyhow, but if the judge believes that, why wouldn't that defeat your claim for prescription that it's marked parking for Dutros for the entire period of time?
My clients had always taken the position that the easement in issue here was to be interpreted for the benefit of both his ownership interest as well as the adjacent Dutra interest.
Isn't a sign that says parking for Dutras market only inconsistent with that?
It is inconsistent. It is inconsistent with respect to the limited number of spaces. There are about a dozen spaces there. And throughout history, again, my client, was never objecting to patrons of the Dutra property, which incidentally, supported and has supported for, nearly a century. A sort of a country store type of operation. And my client never waived any rights and never undertook any activity to endow, the easement holder with any greater rights. In fact, Mr. Freese in his deposition, Freese was the first grantee from the Dutra family after this easement was created, testified that he undertook no activity to divest my client's predecessors of whatever rights they had in the shared use of the easement area. In fact, my client, well, they weren't my client at the time, but the owner at the time, Silver, that began the 20+ year prescriptive period, had gone to the length of signage which divided the property half to Dutra and half to them.
I'm sorry, Mr. Attorney Patton, your time expired about a minute ago, so I think we're going to have to leave it there.
Thank you, Your Honor.
I want to thank you for your argument, and we will now hear from counsel for the appellee, Attorney Zender.
Good afternoon, Your Honors. My name is Ben Zender, and I'm speaking to you from down in Orleans on the Cape. And I have to first say it's a rare privilege to be able to be in front of your panel. The nature of our practice is such that we're not often in front of the appeals court, and I'm very happy to be here. This is really a procedural case. It's not a substantive case. The plaintiff in the lower case sought only a determination of the Superior Court of the meaning of the record express easement. And that was clear as the court has seen in the reading of the materials in the first amended complaint. The last count for declaratory judgment specifically asks the court to determine that my brother's client has a co-use right. And following up on that, when the parties filed with the court their the joint waiver of detailed findings and their special questions, which are analogous to jury questions, They only asked the court to answer questions with regard to trespass, nuisance, intentional interference, and specifically asked the judge to answer the question whether the express easement was an exclusive easement or a shared easement. There was no request. And as Rule 20BH and Rule 28 are very clear about, when you don't ask a court to make express findings, you cannot bring on appeal a question which relies extensively on detailed findings of fact. And there's just no basis for this court to undertake an examination as to whether the court erred in not making a prescriptive determination without a record of that type. So I don't think that this
Counselor,
can be before the court at this point.
Counselor, can we determine whether there is any evidence in the record from which a reasonable trier of fact could find that your easement wasn't prescriptively extinguished to the extent of its exclusivity? I mean, don't we have to make that judgment?
Your Honor, the answer to that question is yes. And as the court knows, the standard for reviewing this matter would be the same as for reviewing a jury verdict, which is there any evidence in the record which would support the determination in favor of the court? And the testimony of Jay Murphy on the stand about the co-exclusive use, or the co-use would be dispositive on the question of exclusivity. The testimony that was supplied.
Counselor, I don't know that exclusivity is the question here, because we have an easement that we accept gives your client, or Dutra's anyhow, and now your client, exclusive right to use this area. And if someone put a fence up there and you didn't complain for 20 years, then you would lose that easement altogether. But if instead they notoriously walked on that every day for 20 years, right in your face, hi, I'm here, I have a right to walk on your property, then after 20 years, your easement would no longer be exclusive. It would now, these people would have the right to walk on it. So I don't know why if they're just trying to show a partial extinguishment to the extent that you don't have exclusive, I don't see why they would have to show exclusiveness. They just have to show 20 uninterrupted years of claiming the right to use the property also. Isn't that right?
I agree with you, Your Honor. There's no question that they could, with the presentation of the appropriate evidence, show a modification of the easement by adverse use. But in this case, they haven't. The only piece of information in the entire record that has to do with a time period, for example, was one of the owners testified that she began to use the parking lot sometime in, I believe it was 1996. The action was brought in 2016. So there isn't even evidence in the record that would establish dispositively that there was a 20-year period. And the reason for that is because, again, the case wasn't tried as a prescription case. So the time period wasn't something that was advanced in any way, shape, or form in the record in order to achieve that element of the case.
I gather the ice cream store started operating around 96 is what we think.
I believe it was, Your Honor. May I proceed, Your Honor?
Of course, yes.
Oh, well, thank you. No, I'm sorry. So basically, what we have here really, and I'll wrap up with this brief comment, is the appellant waived their rights to seek a determination of this appeals court that the court erred in not awarding a prescription judgment on the matter, and they did that when they waived the detailed findings of fact. Now, what the appellant is really trying to do is trying to retry this case as a prescription claim, when in fact it was tried as an exclusive use, I'm sorry, as an interpretation of a record easement claim. And because they didn't bring that claim down below, I don't think they can bring it now. Well, and I'll let my remarks sit there.
In their memorandum of law for trial, they said alternately, any right to the exclusive use of the easement area by the defendants has been abandoned or extinguished by the prescriptive use of the 4 Highland Road property by the successors and interests of Robert S. Dutra. Isn't that enough to raise the prescription? I understand your point about how generously we have to review this because of the waiver of the findings, but why isn't that enough to raise the claim? It's not their main claim, but why isn't it enough to raise it as an alternative claim?
I believe, Your Honor, it's enough to raise it as a claim to be tried, meaning it puts the parties on notice in terms of discovery practice and trial preparation practice of the information that may be presented at trial. But by waiving the detailed findings of fact, I don't believe that it leaves this court with enough information to rule that the court erred in any way. And I have to finally say, a careful reading of the appellant's brief, and we actually handed this off to our summer interns to look at as well, because we thought it would be interesting to them. We combed that brief looking for an allegation of error by the lower court. There simply isn't one. There's no allegation that the court erred. There's only this attempt to reframe this matter before this court as a prescription case, and essentially saying the court didn't properly award a prescription claim when in fact it wasn't tried. And thank you all.
Checking. Justice Ditkoff, any further questions? No. Justice Hand? No, seeing none. The case is submitted. I'd like to thank counsel